Highly here. Yes.
Upon notice, my lord, I am mentioning applications.
Applications in connection with second appeal.
Second appeal and my lord, first mention.
What applications?
One is my lord application for substitution, and others are my lord for injunction.
Injunction. You are for the appellant. Injunction for the second appeal in the year.
It is of 2014 is the first mention appeal, and second appeal is 2016, 2009, and my lord 2012.
3 appeals.
4. One first mention appeal and 3 are second.
Injunction in connection with which appeal?
Injunction in connection with my lord second appeal. It is my lord
2012.
2009.
2009.
In this matter, I am for the respondent.
You are for the respondent.
Yes.
Injunction order was passed.
No, application for stay was granted at the time of admission, stay of the execution proceeding. I have the landowner. Well, now they are proceeding with the construction. Therefore, I have prayed for injunction.
You have filed an injunction application. Serve notice?
Yes, notice. If all matters not, I have given. I'm good.
Listed.
Public notice, please.
Second appeal for hearing. You are?
I am for the appellant.
You are for the appellant.
Yes, Lordship, all the applications of Lordship, and I have already.
Have you served notice? Okay. So WhatsApp.
Lordship, I have already annexed to here.
What is the procedure for serving WhatsApp message?
Went there to.
Now you serve notice to the learned counsel who appearing on behalf of the respondent.
WhatsApp, Lordship, again I am serving today, Lordship. I have already annexed here with the.
No, I shall not accept your WhatsApp message.
Then I.
You can mail or you can serve a notice by filing letter or like that. WhatsApp will not allowed here.
And another matter, Lordship, application. The application there is Lordship related to second application.
What application? You are the appellant. Have you served notice?
Yes, Lordship.
Again, WhatsApp.
Is in 2023. I have already annexed with the affidavit of service. Lordship and direct.
No, whether you have served it before mentioning.
I have served in 2020.
No, you have to serve it before mentioning. Okay. So on Monday after service.
Yes.
All the matters.
Your Lordship, may I be permitted to mention one matter?
Yes.
For incursion in the daily list, Your Lordship. It's a second appeal matter. It was already heard before the Honorable Justice Ajay Kumar Mukherjee. He was pleased to direct the matter to be appear in the hearing of appeal hearing in the month of May on the date of 14th on the 14th May of 2024. Since then, the matter is not appearing in the daily list, Your Lordship.
So you are the?
I'm for the respondent, Your Lordship.
Have you served upon the notice
Yes, Your
upon the appellant?
Yes, Your Lordship.
Okay.
Grateful, Your
You serve it.
This matter was disposed of before Your Lordship, my lord. 23rd November 2023.
Very well.
The Sparta came up before Lordship on 16th May 2024 for correction. And my lord, that as I had, my lord, your lordship was pleased to direct me, lord, to pay the interest amount. The interest amount 22,000. This is ready. But my lord, when I went to comply with the lordship's order, my lord, this is not displaying in the website. My lord, I intimated the entire thing to the learned advocate with the appeal, and my lord, he is also not with the, my lord, copy of the order. Then let it appear as to be mentioned. My lord, in the meantime, my lord, period of the, my lord, demand draft also expired, my lord. So your lord, unless your lordship grant me leave, my lord, it's not, it will not.
Not in website order?
Lord, it's not, my lord. I've given, my lord, the first order, the mother order, my lord.
All order is uploaded to the
So
website.
I think some difficulty, technical difficulty may be there, my lord. Maybe because thereafter FMA number, my lord, was there subsequently. Initially, it is FMA 80 now. However, initially it was in the website, but when I searched it for compliance, my lord, and I've gone to the website, my lord, the first order, this is not available.
No. For execution of the order or for receiving the money, you have to receive the certified copy from the department. Server copy would not sufficient.
I rightly pointed out, I committed mistake, big mistake on my part. Not from the department, they have sent it.
So why you mention it today? What is your purpose? What you want?
Extend the time, perhaps the time that given by your lordship.
The check has been expired. Now going to expire.
My partner, I'm admitting it. And why
Okay.
it was mentioned to your lordship earlier.
To be mentioned.
My lord, may I be permitted to mention one matter? Lordship passed an order of restoration on 10 January 2024. Subject to payment of cost of rupees 10,000. I have paid the cost. So Lordship have also directed in the order that the matter should be mentioned after payment of the cost, my lord. So let the matter appear under the heading to be mentioned.
Have you served to the learned
Yes,
counsel?
my lord. I have served. I have annexed everything, my lord.
Okay.
The photocopy of the cost.
Monday to be mentioned.
My lord, may I be
Yes,
lordship
something.
mention, my lord, this is an application for substitution. My lord, the
In
petitioners,
connection with second appeal.
no, in connection with the REIT application. In 2009 REIT petition.
Can application is there?
Only can application, substitution.
Okay.
Because it has been shut upon all the bank.
Read group 8.
REIT group 6.
No, I don't have determination.
The service matter?
Lordship
Nahi?
mentioned. Lordship urgent, my lord.
I'm sorry.
Second appeal, my lord, I have already mentioned and the
Service
matter
below.
is appearing in the list. But my lord, is for upgradation. My lord, I have served notice before
What is the-
mentioning,
What is the list number?
my lord, the list number 200 from the combined monthly list. 200,
My combined monthly list though?
200, my lord.
What is the combined monthly list? Let me see.
Two hundred, 200. Bodo Kumari, my lord. Year 2010. Very, my lord, senior citizen, aged person, my lord, 90 years old, my lord. Sitting, my lordship, if your lordship, any, my lord, except, my lord, 24th, my lord. Something.
Second appeal of 2010.
Yes, my lord, my lord.
Second appeal of 2000 number.
Number 383, SA 383.
What is the urgency?
The urgency, my lord, is aged person, my lord, 90 years
All
old.
are the agent
And
persons.
No, my lord, I have tried my level best, but suit for declaration and some give compensation. Well, if some amount is paid that against the state, well, I have sub notice state as well as the private respondent, my lord. And before mentioning, I sub notice, and again, my lord, today I mentioned, I have also, my lord, give notice. Well, any day, my lord, except 24th, my lord, I beseeching my lordship. If your lordship, any
2006, 2007, 2008, 2009, all the whole appeals. 2005,
my lord, my
2000,
yes, my lord.
1989, 74. These are the old appeals pending.
my lord,
How can I upgrade your matter?
my lord, any day, I'm visiting my lordship, my lord, any day, my lord.
74
And-
matter all has expired. Now their predecessor came
my
for
lord,
disposal of the appeal.
I come, my lord, some compensation, my lord, I'm get, my lord, very old matter. Some
What compensation you want in civil matter?
my lord, you suit for declaration and recovery of some amount. And state is ignored. That is not, suit is not maintainable, other thing. But well, I'll give you some more decision.
What happened before the learned trial court?
Calcutta, my lord, same. My lord.
Dismissed.
Yes, my lord.
Trial court dismissed.
Yes.
First appellate court also dismissed.
Yes, my lord.
And you
The
prefer the
judgment
second appeal.
Yes, yes, judgment of affirmance, my lord. Suit for recovery, I am for the plaintiff appellant.
Plaintiff appellant.
My lord, any day, your lordship, as your lordship suits, my lord. I do not know.
I cannot accommodate you before February. In this month, it is not possible.
February, my lord, February, any day, my lord. First week of February, my lord, I visit.
No, first week of no, not first week.
Third
21st. February 21st.
May be
For
permitted,
hearing. Within first 5 matters.
your lordship may be permitted to mention, your lordship may be permitted to mention.
Just wait. On mentioning 200 আজকে লিস্টে নেই তো ও লিস্টে নেই তাহলে আপনি এমনি করুন আচ্ছা ফ্রাইডে তো অর্ডার হবে come on Friday
Lordship, may I
on
permit,
Friday
My lord, to 21st February, your lordship kindly, my lord.
come on Friday yes
may,
it is not daily supplementary list today okay that's why the order cannot be passed
Lord, I'm giving the notice.
you come on Friday okay
Lordship, may I permitted to mention one contempt application. I have mentioned before your lordship on Monday, your lordship wanted to see order passed by you. Kindly see the order. The last order was passed by your lordship and the judgment was passed Justice, Honorable Justice Muralidharan. Later on, one contempt application was filed with the respondent authority that was disposed by your lordship.
no group 6 matters
But
I-
lordship, last order was passed by your
whatever
lordship.
may be the order original order
It
is
is
for group
contempt
6
application, lordship.
contempt application in respect of group 6 I don't have determination I have passed the ex parte order you have vacated the ex parte order but the group 6 is not my determination
Actually, lordship, the last order was passed by your lordship.
they have not violated the last order they have violated the uh, order passed by Justice Muralidharan
Yes, lordship.
then you go to the proper court group 6 matters is there with the other determinations
May I,
May I be permitted to mention this matter, Lordship, for inclusion in the list. Lordship had heard.
appeal
No, Lordship, this is a writ petition, Lordship. Lordship had heard this matter. The returnable date was 8 days after. Lordship was pleased to hear this matter on 1st August 2024. The returnable date was 8th August. Thereafter, it never appeared in your Lordship's list. Went out of the list, Lordship. Just praying for inclusion.
why you not mention it then August is there
Lordship, I had my advocate on record has given instructions to mention this.
why you mention not mention it I have directed the it is returnable
Lordship,
then
I have been told that the writ petitioners are facing some kind of difficulties as
group
they
8
are-
matters
Lordship,
okay please take.
your lordship, the same cause of action, your lordship, the returnable date was in the 3rd week of August, your lordship. The impugned order was passed by your
Group
lordship.
8
Group 8 matters, your lordship. Wait for the lordship.
call the list next
I am appearing for the appellant lordship, appellant
Yes.
plaintiff appellant lordship. 25
The assigned matter.
Assigned lordship. Matter was released by Justice Ananya Banerjee lordship.
What is the matter?
Matter is plaintiff filed a suit for declaration and permanent injunction as well as recovery of the khas position
First
lordship.
appeal.
Yes, first
First
appeal.
miscellaneous appeal.
Yes.
Okay, first miscellaneous appeal.
Lordship, thereafter, lordship, on depriving the order of the civil judge junior division, the plaintiff filed an appeal before the senior division. And that appeal, that order was challenged before the Honorable High Court. Honorable High Court admitted that appeal. Order was passed. Status quo order was given until disposal of the appeal. And in between, in the pendency of this appeal, opposite party filed an application for extension of time period for the repairing work.
Extension of time period for
the repairing work.
repairing work.
That was order was passed by Honorable Justice Soidullah Munshi Diden. Lordship, the time period was given 30 days. Beyond that day, Lordship, in the year, order was passed in the year of 2018, Lordship. And 19, they filed an application for extension of time period, Lordship. In this period, Lordship, they constructed the toilet and cattle house on the property of the plaintiff, Lordship. I filed an application for the violation of the order as well as the objection filed by the plaintiff lordship, plaintiff appellant lordship. That two application is pending here, and lordship fixed the date for hearing. Lordship, first two application is to be disposed of, and one direction is to be given by lordship for the paper book, lordship, because this is a transfer by see the order of the Honorable Justice Jyotirmoy Bhattacharya and Ishan Chandra Das. Direction for the paper book, lordship. After getting the LCR from the court below, the direction was given, lordship. But I did not get any information from the department whether the LCR has come or not. That direction is এসে গেছে তাহলে এটা আমাকে নোটিশ একটা করতে হবে তো নোটিশ না দিলে তো পেপার বুক তৈরি করতে হবে না
Where is the order book?
Lordship, this is a server copy of the order of Eden Justice.
Just wait.
Kindly see.
Order book কোথায় তার এখন order book আছে ওখানে page.
Lordship, two application which is pending before the lordship, that application is to be disposed of first. And one special officer was appointed by the Honorable Justice Soidullah Munshi Diden, the Nirmallo Dhara, who is a practicing advocate of this Honorable High Court Lordship. He was appointed. He already.
Let me check out the record. Just wait. What are the cans?
There are two can. One can filed by the opposite party, respondent lordship, regarding the extension of time period.
Can number?
Can number 5.
Can number 5.
Against that application, I file the opposition lordship. And stating the fact that in place of the repairing work, the construction is over. And the order passed by Justice Soidullah Munshi regarding the plot number, that plot number is not in the can. The different plot number is there. And this can was filed in the year of 21.
Can 5 of 2021.
21. The extension of time period. The order was passed in the year of 2018.
Now, and another can?
Another can, this is the violation of the Honorable High Court order. That is my application, my can lordship.
Can number?
Can number 6. I am annexing the order of the Honorable Justice as well as annexing some document lordship. That is the photocopy, what they have done. As
What
well
is
as
the prayer of your can?
yes, my prayer is violation of the Honorable High Court order.
Then what is your prayer?
At this moment,
In can 6.
can 6 is to be my prayer is
Violation
to
of order
pass
of
the appropriate
injunction.
order.
Violation of order of injunction.
Yes, my
That
prayer
is the
is
provision order 39 rule 2A.
yes, my prayer is for the pass the appropriate order.
What appropriate order you want?
That is
There is a
they
specific
violate.
provision.
Yes,
Under order 39 rule 2A, you have to
Yes.
file a specific application. That is the separate issue altogether.
I filed this application regarding the violation of the order of the Honorable High Court.
Yes, you know the law.
Yes.
Then order 39 rule 2A is there. You have to take a separate proceeding.
Then I will have to file
Yes,
it before
yes.
the
That
court.
is the CPC rule.
Yes, but
Then-
the order passed by the Honorable High Court here, Lordship, due to that is in I have filed this application here. Then again I will have to go there.
By such application, you cannot pass. You cannot get any order under order 39 rule 2A. If you substantiate order 39 rule 2A, then you have to file one miss application or miss case like that.
Then
There is a
again,
provision, you go to the
yes,
CR.
but then again I will have to file this application because the violation has
You
been
can
done.
file a contempt against the order before this appellate
The
court.
order was passed in the year of 2018. The contempt time period that was gone.
Very well.
Not only that, what they pay 39. Can you see the lordship? What he is prayed for extension of time period of the repairing work on the plot number.
Who is appearing for the respondent?
Respondent Prosenjit Mukherjee lordship. Order dated Justice Ranonna Banerjee's order lordship. It is reflected that the application which was filed by the opposite party regarding the repairing work on the can application plot number 3493 and 3494. But the order passed by Soidullah Munshi on 3491, the plot number.
Okay.
It is the order of the Justice Soidullah Munshi. I already annexed in my opposition lordship. It is clearly stated the RS plot number 3491. And so Soidullah Munshi submitted the status report, direction for the submit the status report. But he submitted the report. I came to know that the report of 2019 lordship. Nirmallo Dhara.
Yes. So can 5, what is the objection?
My objection is in place of the repairing work, construction is over, Lordship. I already annexed the photograph, everything on the property of the plaintiff appellant, Lordship. The advocate commissioner was appointed, report was submitted, and it is clearly stated that this was the encroachment. But during the pendency of this appeal, Lordship, more than that has been encroached. My prayer before the Lordship at this moment, Lordship, kindly give the direction for the submit the report of the current status report of the suit property.
This court in the order dated 12/6/2018 has passed
Yes.
the order. Justice Soidullah Munshi.
Yes, yes.
This court has allowed the defendant respondent to undertake some essential repair at arrest plot number 3491
One.
and also passed an order restraining the defendants to make any unauthorized or illegal construction over the suit premises.
And special officer was appointed, Lordship. Direction for the special officer on the observation, under his observation, the repairing will be done. And time period is given 30
So what
days.
is the prayer of CAN 5?
Extension of time period. And that application was filed in the year 2021, and the suit plot is different.
Where is the CAN 5? CAN 5, where is the prayer? That making construction over non-suit plots. Only pray for extension of time
Yes.
for
In
making
connection with the order of the Honorable Justice Soidullah Munshi.
Yes, order dated 12th of June 2018.
The suit plot is different, and time period is over. 30 days was limitation was given,
So
and the order application was filed in the.
how you are saying that the suit plots are different?
Yes, kindly see the order of the Honorable Justice 3491 and the prayer property of the application of the opposite party. See, Lordship.
Refer me the paragraph.
Para 2 is clearly written, Lordship. From the inspection reports, it appears that the building standing on 3493 and 3494, and that 3494 is stating in the prior part, they extended the time period of order dated 12 June 2018. And this order was passed in the year of 2018. An application was filed in the year of 2021 and praying for extension of time period. The time restriction was given within the time period was given, Lordship, within the 30 days from the date of the order. But the opposite party did not take any step to do that. My prayer before the Lordship, kindly dismiss this application. The time period is already over. An application was filed beyond that. 21. Rightly, wrongly, Lordship, whatever may be the, I filed the opposition regarding that.
Yes, what about 6?
And 6 is a Lordship violation of the Honorable High Court order. Simply, I stated that the order which was passed by Honorable Justice Soidullah Masjid, that was violated. Direction was given to complete the repairing of work within 30 days. That was not done. In respect of that order, the construction was over, toilet as well as the cattle house, everything that has been done on the property of the plaintiff appellant. I already annexed the photograph also. The Honorable Justice Ananda Banerjee stated that the current
All along the case is that 3493, 3494 is the plot numbers where the defendant is residing and making construction, not in plot number 3491. This is the all along case from the lower court. Okay.
But they filed an application regarding the repairing of the work on the plot number 3491.
Order was already been
Yes.
passed. Okay. And your application being CAN 6,
That is the violation.
you have made a prayer for recovery for demolition of another construction.
Yes, yes, yes.
That cannot be passed without disposal of the appeal.
No, without, yes, yes, I am agree with you.
Okay. Okay, please
With
take
the-
down. Hard. CAN 5 of 2021. This is an application filed by the respondent praying for extension of the time for carrying on necessary repair works for a further period of 3 months. From the date as fixed in terms of order of this court dated 12/6/2018. Full stop. None appears on behalf of the petitioner respondent. Learned counsel for the appellant is present. It appears that video order dated 12/6/2018, this court has allowed the respondent stroke defendant permitted court allowed permitted the defendant respondent to undertake essential repair in suit premises at RS plot number 3491 within a month from date. Full stop. Now the instant application CAN 5 of 2021 was filed on 9th of September 2021, praying for necessary order of this court so that the time for carrying out necessary repair may be extended for further 3 months. It appears that the order was passed by this court on 12th of June 2018, permitting the respondents to defendant to undertake essential repair in the suit premises. That is at plot number, that is at RS plot number 3491 within 1 month. The instant application was for extension of time period was passed after more than 3 years. Full stop. The order dated 12/6/2018 passed by this court has also appointed one special officer who shall observe the essential repair work of the respondent. Full stop. The respondent appears to have not conducted the repair work. However, at this juncture, the respondent cannot be allowed further to carry out necessary repair work or for extension of time. Under the above observation, it appears to me that the application being CAN 5 of 2021 is devoid of merit and the same is dismissed. Accordingly, CAN 5 of 2021 is disposed of. Next para, CAN 6 of 2021. This is an application filed by the appellant for appropriate order. It is the submission of the learned counsel for the appellant that the defendant stroke respondent has deliberately violated the order of this court dated 12th of June 2018. So he prayed for necessary order for demolition of unauthorized construction over suit plot number RS 3491. Full stop. It appears from the prayer of CAN 6 of 2022 that the same cannot be determined without disposal of the appeal. Accordingly, CAN 6 of 2022 shall be heard at the time of hearing of the appeal, along with the hearing of the appeal. Let the matter go out of the list, parties are liberty to mention.
Lordship, direction for the paper book is to be time period.
Okay. It appears that LCR has already been received by the department, but no notice of such receipt of LCR has been served upon the learned counsel on record, learned advocate on record for the appellant. In this court, the learned advocate on record is directed to prepare the paper book, prepare the requisite number of informal paper book, and submit the same with the department within 4 weeks within 4 weeks from date. Let the matter
Also
go.
within 6 weeks, because the appellant is residing at Purulia, will have to communicate, they will come.
Okay.
Amol Kumar Banerjee, huh? At a transfer brief. সেই জন্য আমি advocate on record রেখলাম।
Next.
Grateful, Lordship.
Item number 10, Your Lordship, I am appealing for the petitioner. Your Lordship, in this judgment, Your Lordship, in last page of your my lord's order, at paragraph 22, Your Lordship, there is a date, my lord. It is probably it has gone down wrongly as October. It would be September, my lord. 2nd September.
Give me the judgment.
Paragraph 22, last page, Your Lordship.
Page.
Last page, paragraph 22. Last line, paragraph 22.
Yes, memo dated 2nd October.
It would be 2nd September.
2nd September.
Only that correction is required.
2nd September 2010.
Yes, my lord.
Right. Please take down. This matter appears for correction of judgment dated 3/1/2025. Next para, at page 12, in the last line of paragraph 22, the date of memo shall be correctly read as 2nd September 2010. 2nd September 2010. Invert comma instead of 2nd October 2010. Remaining portion of the order is null. Next.
Well, these matters appearing for this
Lordship, in this matter, Mr. Shobhan Majumdar appearing for the petitioner.
last
Lordship,
occasion, my lord,
in this
not in here, my lord. Over telephone, the advocate got tell me that pursuant to the lordship direction, there isn't 2 report is there. I hand over the report, but there's an impression that wrong report is given to the petitioner, respondent, my lord. So kindly keep it next week. And in the meantime, I have the face copy and
Have you filed the report?
already filed. The copy of the report that was handed over
has not been served
that
upon
is
me.
yes already served, but that is another one, man. First one I already served now.
Yes.
Keep it on not to this week, and I come with serve with the second copy and come back. Last occasion I am not here, my lord, at the time of hearing. 2 reports is there, man.
Supplementary affidavit of
Yes, yes.
report. Report in the form of affidavit.
Evidence.
2 reports are there.
Yes, man.
Exception has already been filed. So you have served a wrong copy. Next week, not this week.
Grateful, man.
Grateful.
Next.
In this matter, I am appearing for the private respondent, madam.
Well, I am for the petitioner. My lord,
Well, the case in nutshell is
my lord, I pray for accommodation, my lord. As my lord, we do not have the petition since on the month of June, our chamber got burnt due to a fire breakout. So we lost lot of our briefs. So my lord, so I pray for a copy from the state to give us a copy of the report filed by the state, my lord. and kind of keeps it out of the matter after 1 week, my lord.
What can be done?
The report also got burnt with it. So, my lord, if we could pray for a
What she
copy
want?
of the report.
Whether you want the copy of writ petition?
No, and we don't have the copy. We don't have the report also.
She has no records. So what can be
Just
done?
pay for 1 week accommodation. If the state, my lord, we shall assist him in getting those reports and for
You
making.
deal with your counterparts, not before this court. I just adjourn the matter today.
She has requested me, I my senior to.
Okay, accommodate.
So what documents you want? You want writ petition also?
Petition
Report as director earlier. And then Malad on her prayer.
Yes.
Writ petition and report be supplied to them.
I cannot pass that order.
Yes, my lord.
You just
It's after 1 week, my lord.
very well.
1 week.
Please take down
Huh.
the report in the form of affidavit on behalf of the respondent number 1 to 5
Then I shall.
Yeah, definitely.
be taken on record. Petitioner is at leave to file exception if any.
Within, my lord.
Within 2 weeks.
1 week, my lord.
Within 1 week. Full stop. Let the matter appear in the list under the same heading.
On. Paragraph 14, 15, 22, on 22nd.
22nd.
Yeah.
Yes.
Leave, sir.
22nd.
22nd.
You collect the copies from your counterpart.
If she gives me the letter, I shall supply.
Yes, ma'am.
Otherwise, I'm not going to
Your Lordship, I'm appearing for the petitioner. It is an assigned matter. It is coming for the first day, Your Lordship.
I'm for the respondent number 4, Your Lordship.
It is relating to gratuity, Your Lordship, on a short point with regard to jurisdiction, where the controlling authority will have the jurisdiction to adjudicate the case. I'm a registered company having my office in Calcutta at Hemantu Bashu Sharini. And whereas the controlling authority who has passed the order has passed it in Hooghly.
Who is appearing for the respondent?
Respondent number 4, I'm for the respondent number 4, Your Lordship, private respondent.
Private respondent.
Lordship.
Who is the answering respondent?
It would be the state, Your Lordship.
Lordship,
You are for the state.
Lordship, I will be also the answering respondent because as per my initiation, the case has been proceeded, Your Lordship.
In this,
I got retired from Hooghly. If Your Lordships consider the Payment of Gratuity Act,
Your Lordship, in this issue, 2 judgments have already been passed. I have pleaded it in paragraph number 18 of my petition, page 8 to 23.
I never did with this issue.
I know, I am aware.
You
Your Lordship, I shall.
I have also
precisely tell me what is the law and what is the fact
Your
and
Lordship,
what is
Your
the
Lordship,
objections, everything. Okay.
Your Lordship.
Otherwise, it would be cumbrous for me to deal with the matter. Okay, tell me from the beginning.
Your Lordship, the payment of the workmen worked in my
Who are
factory.
the petitioners?
Petitioner is a company.
Petitioners are the company.
Yes, a
Petitioner
registered
number 1 is the company.
company.
Petitioner
Two is
number
a
2 is the director.
director.
Very well.
Petitioner, respondent number 4 is the workman who had worked in my unit at Hooghly Mill,
Subol Satra.
Chhatra,
Very
which my learned friend is appearing for.
Okay. Yes.
If Your Lordship takes page number 3, paragraph number 2.
3, paragraph number 2. Yes.
As being a registered company under the Companies Act, I have been given certain privilege. First privilege is where I have my registered office. All proceedings against me will be conducted in that jurisdiction. And I will also have a right to be, even right to sue and be sued at the registered office.
Yes.
My registered office and under the Payment of Gratuity Act, there are 2 provisions. One, if a unit is in different districts, if I have different factories in different districts, automatically I fall under the jurisdiction of Central Calcutta
That is the
Where-
registered office of the company.
company.
Though
Same
there may be a different unit in the different districts.
as like if I have interstate units, if I have a unit in Odisha as well, then I will fall under the Central Act.
Central Act.
Central Act. I would not be governed by West Bengal
State Act.
payment of gratuity rules.
Okay.
I straight away go under Central payment of gratuity rules, and Nizam Palace would have the jurisdiction. The workman has worked under my unit, which is located in Hooghly.
Yes.
He retired sometime in 2016. And he filed his
2016.
16.
Okay.
And he filed his proceedings at a belated state.
Proceeding for payment of gratuity.
Payment of gratuity act.
Where he filed the proceeding?
In Hooghly.
Who is the authority before the controlling authority?
Before the
landed
controlling
controlling
authority.
Controlling
Under the
authority.
payment of gratuity act.
You filed the application for gratuity.
Lordship. In Form N.
The West Bengal gratuity rules provide certain forms under which the claims have to be filed, and accordingly reply also under the form.
So which form he have filed?
Form N.
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 M for N.
Form N. Yes.
Lordship.
For settlement of gratuity.
For application, it's a application for direction. This is the Form N is written as application for direction. As the employer failed to pay the gratuity within the stipulated time period, then it will come into play.
My learned senior is here, Your Lordship.
May I have Your Lordship?
Yes.
There are several orders under challenge. At first, the controlling authority was invited to decide as to whether he has territorial jurisdiction over the subject matter. But this was decided against us, for which we preferred a statutory appeal. And in the meantime, when these things were going on, the final order was passed, which is also under challenge before this Honorable Court through this writ petition. Now, please come to the jurisdictional issue having been decided at page 47 first. It is at page 48. But for the time being, I am not troubling Your Lordship with the merit of the claim. I am restricting my submission only to the jurisdictional issue. Please come to the top of that page.
Page 47.
Yes, page 48.
48.
Now, this is the description of the contesting parties with their respective addresses at the very top, not with bold letters.
Yes.
Now, please come to the bottom portion of that page. The last paragraph, the matter was taken up for hearing and a copy of Form N was sent to the OP for appearance. The first hearing was called on so and so. Lordship may skip over that. Then kindly turns over to page 50, the last paragraph. And he goes on to hold that he had worked for 240 days. Then please come to page
50, the last paragraph.
Yes.
Bold.
Therefore,
being a case of unpaid gratuity.
Therefore, being a case of unpaid gratuity, dismissing the plaintiff on technical ground of limitation without providing him a reasonable opportunity of being heard would not in any way advance the interest of justice, but admittedly result in failure of justice. Then what he refers to the documents produced in course of the inquiry. Then please come to paragraph D on that page 51.
Yes.
The contention of the OP that the applicant joined as a Badli or casual worker and he never rendered continuous service of 240 days in any year during the Badli period of service is again misconceived. Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than so and so years. Then please skip over the balance, the rest of the page. Kindly comes to paragraph E on the next page. Just above paragraph E. Just above paragraph E. This is also written in bold.
Yes.
So contention of the OP that the applicant is not eligible for gratuity during the tenure of his casual or badli worker is again misconstrued. An employee under the Gratuity Act is anyone employed in any capacity in relation to the employer's business, regardless of whether the employment is casual or temporary. Another striking feature of this instant dispute is that the OP remained silent on the issue for so long, even being aware of the fact that the applicant superannuated on 2007. It was only when a proceeding was initiated under Section 7 of the Act, the applicant employee, for realization of the gratuity amount along with interest before the controlling authority, came up with the fact that the employee is not eligible for gratuity for the entire period of his service of 33 years and is eligible only for 21 years. Then please straightway comes to the finding at paragraph H of that page.
Yes.
The OP submitted by a petition on 24th April 2023 that the controlling authority at Sirampur under the Payment of Gratuity Act in the matter of this gratuity case number so and so has no jurisdiction to entertain the application of the applicant, as the controlling authority at Kolkata appointed by the state government has such jurisdiction, if at all any. The then controlling authority, after hearing both the parties, has summarily rejected the petition, since the OP has never raised this issue of maintainability during the entire long proceedings of the case.
Yes.
But at the final stage, again, when the same was appealed before the appellate authority under the Payment of Gratuity Act, the appeal was dismissed by the appellate authority by a reasoned order dated 28 February 2024. All these orders are under challenge. In view of the above facts as contained in the aforesaid paragraphs, it is crystal clear that the applicant joined the OP company on so and so and superannuated on so and so. Now, please come to the orders of 28 February 2024 at page 36. So far as the period of Badli worker is concerned, but today I am protected by a division bench judgment which says that during the Badli period one is not entitled to gratuity. But I shall cite that judgment, but when it comes. Please come to page 36 now, because it records that the appellate authority has already held that this Hooghly jurisdictional officer can entertain the application. Please come to page 36.
Order of the appellate authority.
My lord, this is only on the point of jurisdiction. The appellant company so and so, having jute mill at Rishra Hooghly with registered office at Hemanta Bosu Soroni, filed a petition for appeal on so and so in the office of the appellate authority under the Payment of Gratuity Act, Hooghly, and Deputy Labour Commissioner Sirampur against the order of the controlling authority under the Payment of Gratuity Act issued with the order dated 24th April 2023. But the fact of the case, not I need not trouble your lordship not with this fact of the case. Please come to the finding at page 37. Main contentions in the petition dated 2nd March 2023 of the appellant are as follows. Page 37, third line from the top.
37.
Third line from the top.
Yes.
The main contentions in the petition dated 2nd March 23 of the appellant are the following. The appellant company is incorporated under the Companies Act and that its registered office is at Hemanta Bosu Soroni, Kolkata 1. The appellant company runs jute mill under the name and style of so and so, which is controlled and operated from the registered office at Kolkata. The affairs of the jute mill is controlled, managed and administered through the head office at Kolkata. Hence, the territorial jurisdiction to deal with the matter lies with the office of the Deputy Labour Commissioner, Kolkata, and the controlling authority under the said act has no jurisdiction to entertain the application. In support of their contention, the appellant relies upon the decision of the Honorable Calcutta High Court in so and so, in the matter of Bhanu Prakash so and so. The employer is which has held that, quote unquote, the employer is a company within the meaning of the Companies Act, which provides that the notice or proceeding to be initiated before the authority within whose jurisdiction the registered office of the company is situated, ... The controlling authority is the creature of the statute and they are bound to act within its precincts. The affairs of the company is controlled, managed and administered from the registered office. The payment of gratuity is also one of the elements coming within the ambit of administration and management, which is obviously done from the registered office. Therefore, the controlling authority of an area where the registered office of the company situated is competent to determine the dispute under Section 7 of the Act. Therefore, the controlling authority at Barrackpur, North 24 Parganas is not competent to decide the dispute raised under Section 7 of the Act. They further contended that as per section 2F of the said act, employer means in any other case the person who or the authority which has the ultimate control over the affairs of the establishment, factory, mine, oil field, so and so. They also, the next bullet point, they also contended that the applicants under the said act like Form I, etc. has to be submitted at the registered office at Kolkata. Hastings Jute Mill raised objection on the alleged ground that the proceedings cannot be adjudicated before this controlling authority as it lacks inherent jurisdiction to entertain and try this case, and it is not a case of either want of pecuniary jurisdiction or territorial jurisdiction which could be waived. Objection petition on territorial jurisdiction has been rejected by the controlling authority vide his order dated 24th April 23. They prayed to set aside the order passed by the controlling authority. The respondent has on the other hand mainly contended that the employee filed the application for gratuity before the controlling authority on 2016, and since then a number of hearings took place. At almost end of the adjudication process of the case, appellant submitted a petition without serving to the other party, raising objection on the ground that the controlling authority lacks territorial jurisdiction to hear the matter. The memorandum of appeal is premature as per section 7 of the act, as the aggrieved party is eligible to file memorandum of appeal after passing of the order by the controlling authority in Form AR. So the ground taken in defense was that even after final order is passed, this point of jurisdiction can be raised before the appropriate forum. But in the final order, the controlling authority says that I am stopped by the order. So your Lordship's court has to now determine. It's not like section 97 or 99 of the Code of Civil Procedure that once a preliminary objection is decided and I have not raised an appeal, I am stopped from raising it after the final stage.
So here says the memorandum of appeal is premature as per section 7 of the act. As the aggrieved party is eligible to file memorandum of appeal after passing the order of the controlling authority at Form R.
That's after final adjudication.
After final adjudication. Okay.
The appeal is filed without obeying the provisions of 7.7. But 7.7 says that if one has to prefer an appeal, then the amount has to be deposited as a precondition for preferring the appeal. So that's the analogy sought to be drawn in support of the contention that the appeal was not maintainable at that stage, since the statute provides an appeal to be filed only after the final order is passed. The appellant is not entitled to file appeal for each and every step of the controlling authority which is intended to drag the matter. The controlling authority in his order dated 24th April 2023 mainly held that the OP company raised the issue at the extreme end of the proceedings of the gratuity case. The said petition was not served upon the authorized representative of the applicant as well. The authorized representative of the applicant raised strong objection and stated that the jurisdiction point might have been raised in their written statement or during cross-examination, but the authorized representative of the OP never raised the issue at the initial stage or during proceedings. Considering the argument points of the authorized representative of the applicant, the petitioner's submission of the OP is summarily rejected. Now the petition is filed, even after adducing evidence by both the parties before the controlling authority at the stage of argument. There is no sufficient cause that has been mentioned by the appellant for raising the issue of jurisdiction at such later stage, which would have jeopardized the proceeding since 2016 if there succeeds. Now, as per subsection 7 of section 7 of the Act, any person that section 7 is quoted. Please come to note the penultimate paragraph of that page. I need not trouble your Lordship with the provisions of the section. But the paragraph begins with the words clearly the order.
Yes.
By which the controlling authority did not accept the petition of the appellant challenging the territorial jurisdiction of the controlling authority is not an order issued after completion of inquiry as mentioned in subsection 4C of section 7 of the Act. As per section 7.7 of the said Act, appeal can be preferred by any person only being aggrieved by an order under subsection 4 of section 7 of the said Act. Moreover, no admitted amount being payable as gratuity has been deposited before the controlling authority or appellate authority as required for preferring an appeal under section 7.7 and section 7.4 of the said Act. Considering these, the petition for appeal does not have any strong ground to be admitted. However, if the technical aspects of maintainability of this petition for appeal is kept aside for the time being, on the issue of territorial jurisdiction of the controlling authority in the instant case can be seen in the following way. It appeared from extract of the judgment submitted by the appellant employer that it is regarding an employee who himself applied for payment of gratuity before the controlling authority at Kolkata, where the registered office of the company was situated and the matter was transferred to Assistant Labour Commissioner, Barakpur. Without giving any opportunity of hearing to the employee before the alleged transfer, It is also held that the Act of 1972 does not provide any transfer either on an application of the employee or employer or suo motu. It also held that the payment of gratuity is also one of the elements coming within the ambit of administration and management, which is obviously done from the registered office, and therefore the controlling authority of an area where the registered office of the company is situated is competent to decide the dispute raised under Section 7 of the Act. Now, that should have been the complete stoppage to the question by way of an answer. But the factual matrix of the case might be different because the employee might have applied before the controlling authority in Kolkata in the other case. But the ratio was, since the registered office controls the element of or the aspect of gratuity, therefore the case could not have been transferred from Kolkata to other jurisdictional officer.
Yes.
In the instant case, the employee applied before the controlling authority of the area for payment of alleged due gratuity where the factory of the jute mill where the employee had worked is situated, that is Risra, Shirampur, Hugli, and the registered office is situated at Kolkata. Hence, it appears that this instant case is not exactly identical with the matter of Bhanu Prakash versus Assistant Labour Commissioner. But then what about the observation of the coordinate bench of this honorable court? The court says that gratuity issue is being controlled, the element of gratuity is being controlled from the registered office, and therefore it cannot be shifted from Kolkata. That I cannot have two different jurisdictional officers for the same element of gratuity. For X employee, it can't be Kolkata, and for Y employee, it can't be Rishra or Hugli. It's not a question of choice of the applicant. But and the controlling authority under the Payment of Gratuity Act was certainly bound by this, by the precedential value of this Honorable High Court's order. How could he distinguish that factually not in the teeth of that observation that element of gratuity is being controlled from the registered office? And therefore, Kolkata office has jurisdiction.
Yes.
But then he goes on to hold that, please come to the next paragraph. The Hastings Jute Mill is a factory separately registered under the Factories Act, and the applicant is supposed to be a worker of the factory as per the Factories Act. Hence, as per said Act, it is an individual unit being a factory and has a separate statutory identity as per the said Act. Moreover, it may not be wise to compel the poor worker to raise his grievances at a place where the registered office is situated. It may be outside the district in the instant case, which is far from his workplace. Not he superannuated long back. It's not a question of workplace or forum convenience anymore. And in the teeth of this High Court observation, how could there be a question of forum convenience at all? Not forum convenience would arise if there are two fora available and one of them is convenient. But here the court has specifically held that the registered office controls the element of gratuity and therefore it could not have been shifted from Kolkata to Barakpur. Please come to the first paragraph of that page 39. The registered office of the company was situated and the matter was transferred to ALC Barakpur without giving any opportunity of hearing to the employee before the alleged transfer. It is also held that the Act of 1972 does not provide any transfer either on an application of the employee or employer or suo motu. It is also held that the payment of gratuity is also one of the elements coming within the ambit of administration and management, which is obviously done from the registered office, and therefore the controlling authority of an area where the registered office of the company is situated is competent to decide the dispute raised under Section 7.
So in this writ petition, you have challenged all the orders.
All these orders. But if it is an order without jurisdiction, not it can even be challenged at an execution stage. And not this is exactly what section 3 of the Payment of Gratuity Act postulates. This is section 3. The appropriate government may by notification appoint any officer to be a controlling authority who shall be responsible for the administration of this act, and different controlling authorities may be appointed for different areas.
Yes.
So, he could not have assumed jurisdiction in spite of having taken note of the Honorable High Court's order, and he himself accepts that the High Court held like this. Gratuity is an element controlled and administered from registered office. Therefore, the High Court did not allow transfer of the matter from registered office to another jurisdictional officer.
What are the other orders?
The-
6/9/2024.
These are not the orders are basically of two nature. Not one is this jurisdiction, the other is final determination. That's the computation.
So you have the order dated 28th February 2024. This is the appellate authority.
That's the appellate authority.
Appellate authority order against the order of jurisdiction.
Yes.
Against the order of jurisdiction, that is order dated 24th of April 2023.
That's yes, 22nd March or 24th March 2023.
24th of March 2023.
No, I'm sorry, no, that's dated. April, I'm sorry.
24th April 2023. And what is the 6th of
September 24 is that form R.
Final order.
Final order, direction
Final
to
order,
pay.
direction. Direction. And what is the 2nd August 2024?
That's probably 22nd August, page 45. That is appellate authority confirmed the order of the controlling authority.
Okay. Okay, I understand. So is the order of division bench?
It's a coordinate bench.
Coordinate bench. Okay.
That's quoted in page 22 as well. Paragraph 7 at page 22. The same thing that has almost quoted at page 39.
Bhanu Poklas versus Assistant Labor
Yes,
Council.
but I have got a copy of this order as well. You know.
Yes, I understand.
So not this matter requires not a consideration, and not I am praying for stay of operation of the orders.
Yes.
Lordship,
We have a short leave of your.
Lordship, first of all, with regard to the maintainability of the writ petition.
Yes.
Lordship, if your lordships have the book, if your lordships kindly see, consider section 7, subsection 7 of the Payment of Gratuity Act. Section 7, subsection 7 of the Payment of Gratuity Act. Your lordships will find that the order which is under challenge, the final order, is an appealable order.
Any person aggrieved by an order dated order under subsection 4.
Lordship. That is the final order.
Subsection 4A.
Lordship.
If there is any dispute as to amount of gratuity payable to an employee
Lordship.
under this act,
Lordship.
or as to the admissibility of any claim of,
Lordship.
or in relation to,
Lordship.
an employee for payment of gratuity, or as the person entitled to receive the gratuity.
Lordship.
So all are the paraphernalias,
Is there?
not the final order or
No,
like that.
the section 4, section 7, subsection 4A, that proceedings has been initiated by me. That reaches its finality by section 7(7).
Yes.
So I have already availed the section 7, subsection 4A, that I have approached the controlling authority. The controlling authority, after inquiring into the matter, after taking evidence and all the materials on record, pass its order. That is section 7(7). Now, section 7(7) says that if any person aggrieved by the order passed under section 7(7) of the controlling authority, they should prefer an appeal before the appellate authority. Now, why my learned friend has come up before your lordships is that there is a condition, the precondition for preferring any appeal before the appellate authority. They have to deposit the amount which has been adjudicated.
Where is the provision?
Your lordship, section 7(7), your lordships kindly have a look.
No, I want to know,
Lordship,
what are the provision, what are the aspect of subsection 4 of section 7? That is not the final order.
No,
There
that
may
is
be
not
a-
the final order.
There may be
Final
a
order is the
second
section
order.
7, that I have lordship, may I in short I will. Lordship, a person is an employee of any organization.
Yes.
The law says that before 30 days, he should, before 30 days of his retirement or termination or cessation of employment, he should be given an intimation or paid the gratuity on the very date of his superannuation or something. If the said act has been not done by the employer,
Yes.
then what is the procedure should be adopted by the workman? Now, if the workman is still living, the workman should send an application in form I
before the concerned employer. Now, concerned employer, after getting the said form I, can reject the same by issuing form M or accept the same.
Okay.
Now, if the workman died, then form J and form K, that is legal here, or the nominee will come into play. Now here, those parties not coming, your lordships. Now here the form I has been sent. The employer did not respond to the same. So as per the provision of section 7(4)(a), what is your lordships is looking. Now I have the workman filed a form N. Form O has been issued as a summon or the saying that these proceedings has been initiated to the employer. That is the petitioner before your lordship. Petitioner appeared, filed their written statement. The workman filed its rejoinder. Subsequently, evidence took place. At the verge of the completion of the proceedings, they raised an issue with regard to the maintainability of the application or the jurisdiction of the Land Controlling Authority, saying that our establishment's registered office situated at Kolkata, the proceedings should be over there. Against that, the Land Controlling Authority rejected their prayer. On the ground, this is a very later stage, and no copy has been given. There is the order is there. They prefer an appeal against that order. Now, your lordships has already considered section 7(7). Now, section 7(7) says it's a finality. Appeal should be preferred against the order finality.
No.
Lordship.
Let me understand first.
Lordship.
Subsection 4 of section 7.
Lordship.
It never says about the final order or like that.
No. Section 7, subsection 4 is the
any dispute.
Any dispute. Controlling authority.
Yes, any dispute.
Now, appellate authority will come into play only if any order has been passed. May I?
No.
Lordship. Like the trial court. Like the trial court, your lordship.
No, not like that.
Lordship.
You are submitting that order, final order against the appeal against the final order can be passed.
No. Any appeal, the appellate authority come into play when any final order has been passed by the controlling authority.
No, subsection 7 of section 7 says,
lordship,
any person agreed by an order.
An order
under subsection 4.
Lordship. So that has been already adjudicated?
No, any order.
Lordship.
Not the final adjudication or otherwise. Any order.
Any
order may be such that if there is any dispute as to amount of gratuity payable to an employee under this act,
lordship,
as to the admissibility of any claim,
lordship,
of so there may be separate determinations.
Lordship.
So in each determinations, passed an order under subsection 4.
Lordship.
The person aggrieved under subsection 7 of section 7.
Lordship. Section 7.
Prefer an appeal within 60 days from the date of passing. This is the order.
Lordship. That is the section 7(7). That is the order has been passed by the Land Controlling Authority. That is at page number 47. That is the form R.
Form R.
Form R. That order has been passed. Your lordships will kindly see 48 onwards. That is the order of the Land Controlling Authority.
Yes.
Now, my learned senior friend has raised two issues, your lordships. Number one, with regard to the entitlement of the applicant with regard to the quantum of the gratuity, number one. And so far as my understanding goes, that my learned senior friend is not harping on that. My learned senior friend is only on with regard to the jurisdictional point, your lordships. Now, your lordships, kindly consider section 4. Lordship, I am relying on a reported judgment Lordship. Reported in 2012 volume 3 LLJ 731. It is the judgment of the Honorable Gujarat High Court. Your lordship, kindly consider para number 10. Here the jurisdictional point has been raised. Para 7, your lordships, kindly consider para 7 at first. It is, may I be permitted to please?
Yes.
It is pertinent that in his application form N, also the workman declared that his last posting was at Varaval. Here, your lordships, Hooghly, where he worked on the post of and as an inspector. He had also mentioned that his permanent residence was at Varaval. The same details were mentioned in Form I as well. Learned advocate Mr. Mishra for the petitioner has submitted that initially the petitioner was appointed at Ahmedabad and that therefore he filed the application seeking payment of gratuity at Ahmedabad. He further contended that according to the provision contained in the under Code of Civil Procedure, the plaintiff has to file the suit where the defendant resides or at the place of the defendant's business, and that therefore on the analogy of CPC, the application was filed at Ahmedabad. Since the defendant employer has its place at Ahmedabad and head office at Ahmedabad, and that therefore the application could not have been dismissed on the ground of jurisdiction. According to the learned counsel for the petitioner, the application should have been entertained by the authority at Ahmedabad, and there was no reason or justification to reject the application. I have heard the learned counsel for the petitioner at length and also examined the record. At the outset, it is necessary to clarify that the application has not been rejected on merits by the authorities. Hence, it is open for the petitioner to file application at Varaval and get it adjudicated in the event the defendant employer has still not paid the amount due and payable towards gratuity. Furthermore, the application is not rejected, but it is simply not entertained by the authority before whom it was presented, and that is for want of jurisdiction, and with clarification that it can be filed before the authority having territorial jurisdiction. Before proceeding further, it is necessary to mention that as per the scheme or provisions of the Act, on occurrence of any event mentioned in section 4 of the Act, for example, retirement, resignation, provided service for 5 years, in an establishment empowering 10 or more persons is completed, etc., gratuity become payable to the employee, and if it is not paid within 30 days, then application to the controlling authority can be made within 30 days from the date when the gratuity becomes payable. The amount payable is to be calculated in accordance with the provision under subsection 2 of section 4 of the Act. The total number of years of service, that is the length of service, and therefore date of joining and date of retirement and the last drawn salary or wages are the relevant factors details necessary for determining the amount towards gratuity. If the employer fails to calculate and pay the gratuity, then the employee can make application under section 7 to the controlling authority constituted under the Act. Section 3 of the Act confers power on the appropriate government to appoint officer as controlling authority, who is the adjudicating authority having the powers to adjudicate the dispute related to claims for gratuity. The said section 3 also authorized the appropriate government to appoint different controlling authorities for different areas. 10 points, the said section 3, section 4.1 and 4.2 and section 7.1 to 7.3 read thus. Now, your lordships, that has been quoted.
So what you want to say?
Lordships, I am coming to that. Now, your lordships, kindly come to 10.5. Page 4, your lordship. Thus, as per the said, lordship.
Yes.
Thus, as per the said provisions, the controlling authority constituted under section 3 is the adjudicating authority under the Act, authorize the controlling authority to adjudicate and determine dispute related to claims for gratuity, and the appropriate government has the power to appoint, constitute different authorities for different areas. In the present case, it is observed and clarified in the orders or impugned in the present petition that the state government, being the appropriate government under the Act, has in exercise of the power under section 3 of the Act, has constituted, appointed different controlling authorities for different areas in the state. It has come on record that one officer has been appointed as controlling authority at Junagadh for Varaval area, that is the place of the petitioner's last posting, and from where he retired and where his permanent residence is situated. Hence, when for different areas, different controlling authorities are appointed by the appropriate government, then the specific area of operation and their respective territorial jurisdiction also must have been determined and prescribed. Actually, the appellate authority has clarified in its order that the area of jurisdiction for each controlling authority have been prescribed and notified. Consequently, the officer appointed as and constituted as controlling authority for one area will not and cannot adjudicate and determine the claim dispute pertaining to another area, for which different officer is already appointed and constituted as the controlling authority. Furthermore, even in the application filed by the petitioner for claiming gratuity and also in the application or form 1 to page of 10 of the N4 form N, the petitioner has mentioned Varaval as the place where he worked and where from he retired, and also as the place of his permanent residence. The legality and propriety of the two concurrent orders can be examined from another perspective also, petitioner's permanent residential address. So as to get necessary clarification, it was inquired from the learned counsel for the petitioner as to whether the petitioner is residing at Ahmedabad or Varaval. The details about his permanent residential address were also inquired. In response, the learned counsel for the petitioner did not give clear reply, though he continued to submit that initially the petitioner's appointment was at Ahmedabad. So far as the permanent residential address of the petitioner is concerned, from the memo of the petitioner of the petition, that is from the affidavit portion on page 8, it is clearly transferred that the permanent residential address of the petitioner is at Varaval. Likewise, the cost title of the petition also is mentioned that the residential address of the petitioner is at Varaval. Therefore, even otherwise, it would be more convenient and economical for the petitioner to file the application at Varaval so that he may attend the office of the controlling authority. If the application is adjudicated at Ahmedabad, then the petitioner, a poor and retired employee, will have to travel to Ahmedabad from Varaval for attending the hearing for getting his oral evidence deposition recorded. Thus, if the matter is considered from this perspective and in the light of the aforesaid facts, the orders cannot be classified as unjustified or arbitrary. There is yet another aspect of perspective in the light which the propriety, the justification of the impugned order in addition to the legality of the order can be examined, that is last place of posting or work and cause of action or cause for action. In the present case, it is not in dispute that the petitioner retired from the service while his posting was feed Varaval and he was working at Varaval. In the light of the provisions under this act, particularly section 4(1) of the act, it comes out clearly that gratuity becomes payable on occurrence of any event from amongst the events mentioned in section 4(1), which includes retirements or superannuation, resignation, etc. Thus, gratuity becomes payable on occasion of the employment, cessation of employment for any of the reasons mentioned in section 4(1). Differently, put the cause of action and cause for action to claim gratuity arises on cessation of employment and upon being relieved from the service, and consequently the cause can be said to have been arise at the place from where the employee retires or is relieved from the service. Therefore, also the application is required to be filed before the controlling authority exercising jurisdiction in respect of the areas wherefrom the employer retires.
Yes.
It is also not in dispute that in his application form, the application in form I, well, the petitioner's place of posting was working as Varaval. Now, your lordships, so two aspects has been considered in this judgment. Number one, the cause of action. The cause of action arose when the workman retired from the service. Here in the present case, your lordships, the workman was altogether employed at the Rishra. And he get retired from the Rishra.
Yes.
And if your lordships kindly come to your lordships kindly come to the post title of the writ petition, if your lordships will find the
No, that is
residential
not
address.
disputed. That is not disputed fact.
Lordship,
That,
that is the two aspects your lordships has to consider while deciding the territorial jurisdiction. Number one, I am residing at Rishra. If I have to file, I have to come to the Kolkata. Number one. Number two, your lordships, I am a retired employee. At present age, lordships, he is aged about above 70. Number two, your lordships, the last place of posting, wherefrom he get retired. He get retired from the Sirampur, your lordship. That is the only jurisdictional point your lordships has to take into consideration.
what act says about that?
Lordship,
What act is?
Lordship, the act according to this judgment, the cause of action will come into play only when the person concerned.
I have perused the judgment. What
Lordship.
act says?
Lordship, the act is not
Specific to the.
not specific. Not specific, Your Lordship. And they got the unit over there. My deposition has been completed. Their deposition has been completed. Everything has been over, Your Lordship. At the stage of argument, they have raised this issue. If they have any point with regard to the jurisdiction, then they should come with the set plea at the very threshold of their appearance, at the very beginning of their appearance. Because what my learned senior friend is relying, it is a judgment of 2010. So they got the knowledge that it is not that the issue has been decided just now. Just now it has been not decided. And this proceedings has been initiated, Your Lordships, 2016. 2016, the case has been initiated.
Okay.
After 9 years, if have to, Your Lordships, kindly consider that also. He get retired on 2007, Your Lordship. That means already 78 years of age.
There is. Okay. Yes, for the state. Yes. What instruction? You take the mic. I cannot hear.
My lord, we have to take the instruction with regard to the legality of the points, since the answering authority is the controlling authority of the Labour Commission.
Have you annexed the order dated 24th April? 24th April 2023?
Yes, page 29.
Page
29.
Page 29.
Okay. Okay.
Please take down.
I have 2 points to meet as argued.
Yes.
But he relies upon a Gujarat High Court judgment.
Yes.
But first of all, not apropos a coordinate bench judgment, not Gujarat High Court judgment, cannot have even a persuasive value.
Yes.
Second point is not the most pertinent question which your lordship put to the learned counsel representing the private respondent is, what does the act provide for?
Yes.
Please come to section 7 of the act. But please bear in mind, he superannuated in 2007, filed the claim case in 2016 after 9 years. There was a question of limitation raised as well, but I shall come to it later on. Determination of the amount of gratuity. A person who is eligible for payment of gratuity under this act or any person authorized in writing to act in this behalf shall send a written application to the employer. Remember, this employer has been identified in section 2, subsection F. Employer means
Yes.
in relation to any establishment, comma, factory, comma, mine, oil field, plantation, port, railway company or shop. Please come to 3, because not 1 and 2 are central government and local authorities. 3. In any other case, the person who or the authority which has the ultimate control over the affairs of the establishment, factory, mine, oil field, so and so. And apropos this definition clause, please come to page 8 of Justice Tandon's judgment.
Yes.
It's almost in the middle portion of that page. The sentence begins from the middle portion of the line with the words, the affairs of the company.
Yes.
The affairs of the company is controlled, managed and administered from the registered office. The payment of gratuity is also one of the elements coming within the ambit of administration and management, which is obviously done from the registered office. Therefore, the controlling authority of an area where the registered office of the company situated is competent to determine the dispute under section 7 of the Act. Therefore, the controlling authority at Barracoor is not competent to decide the dispute under section 7. So the ultimate control, administration and supervision is vested in the registered office, and the employer is the person in control over the affairs of such office, even in respect of a factory. But there are penal provisions of warrant of arrest to be executed, will the factory supervisor be arrested or the director will be arrested if there is a default in compliance of the order? It's recoverable under the Bengal Public Demands Recovery Act, 1913. Please come to section 8 of the act also. Recovery of gratuity. If the amount of gratuity payable under this act is not paid by the employer within the prescribed time limit to the person entitled thereto, the controlling authority shall, on an application made to it in this behalf by the aggrieved person, issue a certificate for that amount to the collector, who shall recover the same together with compound interest thereon. Employer means the person having ultimate control over the affairs of the factory. And that's what has been explained in page 8 of His Lordship Justice Tandon's judgment.
Okay.
So that the cause of action theory, like the Code of Civil Procedure, is not applicable in this special statute. Sections 20 and 21 of the CPC will have no manner of application because it identifies the person from which it is to be recovered. It's neither the place of residence of the claimant nor the last place of working.
Very well. Anything?
These are my submissions.
Okay.
And only one judgment, but a very recent judgment of the division bench, note that Badli period is not to be reckoned. It's not reported yet.
These are the merits of the matter.
That is on merit. That is on
the merits of the matter.
That is on merit.
Okay, please take down. Respondent number 4 was employed under the petitioners who superannuated from his service on 2nd February 2016.
No, he superannuated in 2007.
2007.
Filed in 2016.
Okay. Superannuated in the year 2007. Full stop. So superannuated from the service.
July 2007.
30th
13th July 2007.
30th July 2007.
One speak, Your Lordship.
Full stop. He applied for the recovery of unpaid gratuity with the present petition. Full stop. The said amount was not paid. Accordingly, one proceeding was initiated under section 7 of the Payment of Gratuity Act 1972. Full stop. During the course of proceeding, the petitioner filed an application, raised one point before the controlling authority, that the said controlling authority have no territorial jurisdiction to entertain the proceeding. The order of the controlling authority, video order dated 24th of April 2023, has 24th April 2023 has turned down the objection of the petitioner. Full stop. The petitioner has approached before the appellate authority. The appellate authority has also not considered, has also dismissed the appeal on 28th of February 2024. In the meantime, the appropriate authority has disposed of the entire proceeding and passed an order of payment of gratuity in favor of the respondent number 4, private respondent number 4. Full stop. The instant writ petition was filed challenging the orders passed by the controlling authority as well as the appellate authority, whereby they turned down the objection raised by the petitioner regarding territorial jurisdiction. Full stop. Learned counsel, Mr. Somo Majumdar, senior counsel, Mr. Somo Majumdar, appearing on behalf of the petitioner, submits that the controlling authority who adjudicated the matter controlling authority Sirampur Hooghly have no jurisdiction to determine, had no territorial jurisdiction to pass any order under the payment of under section 7 of the Payment of Gratuity Act. Under section 7 of Payment of Gratuity Act, it submits that the definition of employer as enumerated under section 2 within bracket F denotes that employer means in relation to any establishment, factory, mine, dot factory, comma, mine, dot, is the authority which has ultimate control over the affairs of the establishment, factory, mine, etc. Full stop. It is the case of the petitioner that the petitioner having their registered office at, where is the registered office?
It's in
Registered office at 15
Hemanta Basu Saroni.
15B Hemanta Basu Saroni, Kolkata 7001. So the controlling authority at Kolkata is have territorial jurisdiction, to decide the issue. Full stop. In support of his contention, he cited a decision of this court, decision of coordinate bench of this court, passed in Bhanu Prakash versus Assistant Labour Commissioner and others. Bhanu Prakash versus Assistant Labour Commissioner and others, within bracket WP number 9532W of 2010. Mr. Majumdar argued that the coordinate bench of this court had specifically observed in the said judgment that the affairs of the company is controlled, managed and administered from its registered office. Full stop. The payment of gratuity is also one of the elements coming within the ambit of administration and management, which is obviously done from the registered office. On such analogy, Mr. Majumdar argued that the impugn order passed by the learned Mr. Majumdar argued that the impugn orders passed by the controlling authority as well as the appellate authority is beyond jurisdiction, and he prayed for stay of the operation of the impugn orders. First, counsel appearing on behalf of the private respondent has raised vehement objection and submits that the respondent number 4 was an employee of the petitioner who lastly served under the factory of petitioner at Risda, Hooghly. Full stop. He is aged about 70 years.
75, more than 75.
More than 75 years. His payment of gratuity was not made by the present petitioner. Accordingly, he applied before the controlling authority for payment of gratuity. Full stop. The proceeding was initiated by the controlling authority by issuance of summons. Full stop. After receiving the summons, the petitioner never raised the objection of territorial jurisdiction before the controlling authority. The full stop. The respondent number 4 as well as the petitioner has appeared before the controlling authority. Evidence has been laid. No, evidence action has been concluded. But at the time of final hearing, the issue of
At the time of argument,
at the time of argument, the petitioner has raised the issue of territorial jurisdiction. Learned counsel for the respondent number 4 further submits that the learned controlling authority has correctly observed in the order that the issue of territorial jurisdiction is a technical ground which which cannot be entertained at the latter stage. Full stop. The petitioner approached before the appellate authority. The appellate authority has also turned down the prayer of the learned counsel for the prayer of the petitioners. Learned counsel for the respondent number 4 has placed his reliance upon a judgment of Honorable Gujarat High Court, a judgment of a single bench of Honorable Gujarat High Court, wherein the Honorable bench has discussed the issue of territorial jurisdiction on the basis of the residential address as well as the last serving place of the workman. He has placed the judgment and argued that the Honorable bench of Gujarat High Court was satisfied about the fact that when the workman was served lastly in a place, the adjudicating authority, the adjudicating authority stroke the controlling authority of this place should have territorial jurisdiction to determine the claims for gratuity of that workman. Full stop. Next para, it appears that the entire payment of gratuity, entire order of payment of gratuity passed by the controlling authority as well as the appellate authority has been challenged before this writ court. However, the petitioner, full stop. However, next para, the petitioner has raised the question of territorial jurisdiction of the appropriate authority. Before enter into the merit of this matter, let me consider the definition of employer as enumerated section 2 within bracket F of the Act 1972, section 2F C. এটা করবেন না, পেজ 5 এটা করতে হবে, দেখুন 2F এটা তুলতে হবে। না না না, শুধু 2F লিখে এইটুকু লিখবেন, এইটা ডট ডট করে দেবেন, লিখবেন শুধু 3টা লিখবেন, 3টা লিখবেন, ঠিক আছে। Section 7 within bracket 1 of the said act read as follows. Section 7 within bracket 1 টা করবেন, 7(1) page 21 1 টা করবেন। It appears from the provision of section 7(1) that a person that an employee who is eligible for payment of gratuity under this act or any person authorized in writing, authorized comma then, in writing to act on his behalf shall comma send a written application to the employer, full stop, to the employer. Employer bold করবেন within inverted comma মধ্যে রাখবেন, full stop. So the application for payment of gratuity has to be made by the employee to the employer, full stop. Employer as defined under section 2F has mentioned the person, has mentioned the authority which has the ultimate control over the affairs of the establishment, full stop. The petitioner has specifically demonstrated that he has his, the petitioner has its registered office at 15 capital B Hemant Post Soroni, Kolkata 7001. So prima facie, after hearing the petitioner, next part, prima facie, it appears to me that the petitioner has demonstrated an arguable case before this court regarding the question of territorial jurisdiction of the controlling authority as well as the appellate authority to determine the question of payment of gratuity of respondent number 4. It appears to me that prima facie that the order passed by the controlling authority as well as the appellate authority is beyond territorial jurisdiction. Jurisdiction, full stop, jurisdiction, lack of, full stop, lack of jurisdiction, full stop, no, lack of jurisdiction, strike at the root of the order, strikes at the root of the order. So at this juncture, I find justification to pass an interim order in favor of the petition. Justification, I find justification to pass an interim order in favor of the petitioner. Under the above observation, the impugn orders passed by the learned controlling authority as well as the appellate authority is stayed for a period of 8 weeks from date. Full stop. The respondent authority as well as the state as well as the private respondent is leave to file affidavit in opposition against the writ petition, exception if any, no, reply if any by the petitioner, no, by affidavit within within 4 weeks from date, reply if any by the petitioner within 2 weeks thereafter.
Grateful to your lordship.
Let the matter go out of the list. Particularly better.
Grateful to you.
That had to be appeared, your lordship.
After 8 weeks.
After 8.
Liberty to mention?
Assignment. 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 Okay, release me.
Next. Thank you. Huh? একটা কি আছে? আছে সময় দিন। 1 PM matter.
Yes.
Madam, led by Mr. Ananta Kumar Shaw, yesterday this matter was, yesterday your lordship was pleased to take up this matter. Lordship may kindly take the trouble to recall that here, my lord, the basic, my lord, prayer of the writ petitioner is consideration of her representation. My
Lord,
lord,
we are taking a preliminary point of maintainability. And the same cause of action, one writ petition filed, one arbitration petition was filed, that was withdrawn without any leave. Well, it's a preliminary ground I'm taking, well, it's the maintainability of the writ petition.
now may I respond?
I'm private respondent.
No, the earlier writ was withdrawn without any leave.
Without any leave.
My lord, it was filed challenging the order of termination.
Yes.
Today, we are not, my lord, assailing the order of termination of, my lord, the agreement. My lord, today we are, my lord,
Page
seeking, my lord, we are
160.
accepting, my lord, the order of termination, and we are seeking, my lord, consideration of our representation for grant of, my lord, a fresh dealership in mind.
That means the cancellation has to be, my lord, withdrawn and then.
They have accepted. They have accepted your cancellation.
Once, my lord, the acceptance of the my lord, cancellation, and in another
You are appearing on behalf of
private respondent, we am the co-sharer of the.
private. You, I
am
want to
appearing
know.
for the Indian Oil
Yes,
Corporation.
what is your objection?
Lordship, my objection is this. This is they have apparently have prayed for a direction upon the respondents to consider the representation. Lordship, representation for allowing, for granting them another dealership. Lordship, we are not in any way authorized to grant any dealership unless and until the Union of India allows it. This is the absolute territory of the Union of India. Unless and until there is a notification, we cannot appoint any dealer.
I understand. I know.
And that dealership has been terminated. They have not challenged the dealership subsequently.
What is their prayer in the representation?
To direct the respondents to consider their representation.
Yes.
167.
What is the
163, 163, my lord, and
prayer for
167.
renewal?
Renewal.
Prayer for renewal, there are alternative prayers, my lord, which were made in the representation. First is, my lord, renewal of the dealership, and second is in the alternative issuance of a fresh dealership and execution of a fresh dealership.
At page 12, your lordship.
And page 60 is the earlier writ petition. Page 60. 160.
Let them consider, and if,
There is
my lord,
an
they are
arbitration
desirous
clause-
of, my lord.
there's an arbitration clause between the petitioner and the private respondent.
Yes.
Now that
Agreement terminates, arbitration terminates.
agreement has not been terminated.
Yes, agreement, the
For
dealership
an
agreement.
arbitration clause for the arbitration proceeding has been drawn up before this honorable court, before the chief justice, and then that has been withdrawn. Kindly have a look. This is the order.
That was
That
between
is, my lord,
the
between
partners
the
of the
private
petitioner.
parties.
Yes.
That is between the
No, no,
private
I want to
parties.
know about the. You are not now here. I want to know the IOCL.
Lordship, in IOCL stand is this. Since there was a termination of already termination is there, they cannot.
Termination has affected.
Yes.
They have admitted your termination order.
But their representation was kindly lordship comes to the prayer at page number 12.
Number 12.
Writ petition prayer.
No, no, I am
Same
not.
prayer in the
I am
earlier
not
writ petition.
considering
Read
their prayer.
and or in the nature of mandamus commanding the respondents and each of them their main agents, assigns and subordinates to renew the dealership. To renew the dealership of petrol, MS high speed diesel of retail so and so, and or issuance of fresh dealership and execution of fresh dealership agreement exclusively in relation to the existing pump Kishan Seva Kendra, exclusively in favor of a petitioner in pursuance of the representation dated so and so. Lordship, in the guise of representation, their lordship seeking a renewal of their dealership by filing this writ petition.
It is all
That is
prayer.
It is not within your ambit. You may reject it.
Yes.
Lordship, the only
Let them take a
their
decision.
prayer is
No, they have appeared before this court by virtue of a notification of state of West Bengal.
Yes.
That the land used for the petrol pump cannot be used otherwise.
Yes.
Lordship.
This is their embargo to use the land. They have appeared you may reject it. Under your rejection, they may approach the state government so that they can use the land.
Lordship,
This is
I
the only
understand your
purpose.
I understand Lordship's view. Lordship, the classification of land, that has not got nothing to do to with the Indian Oil Corporation.
You
That
are
is
not doing
that is between the government of West Bengal and the
Government
petitioner. They can take up the issue with the
They
petitioner.
will take up the issue. I am not going you to say that
But
they
in
will take up the issue.
the guise of this writ petition, whatever the submission made,
Disposing of his representation today itself. I am sending the representation to you. You to reject the send.
Now, my lord, I'm putting one
That-
question, 167 representation. Can you have a look?
160.
That is his representation.
Yes.
Now, fourth paragraph, unfortunately, the other partner, Mr. Ganesh Chandra Rai, refused to discharge. That is his main contention.
No. Milord,
Kindly look, my lord, whether
he-
the Red Court can
Sir.
decide or Indian Oil can
Milord,
decide.
Milord, as far as my representation is concerned, he is no one.
He is no one. And that is why arbitration proceeding is there.
And that is
They
a
withdraw.
separate issue, Milord.
Not separate.
That cannot be clubbed with this matter.
Kindly have a look of this order. Kindly
Your Lordship will appreciate
one
on the
of
earlier occasion.
and arbitration appointment of arbitrator. Kindly have a look.
On the earlier occasion, I have
Why it has been withdrawn, what
point-
this has been withdrawn.
pointed out to your Lordship. না ছিলাম না হুম।
It is unfortunate that the learned advocate appearing for the private respondent is seeking to instruct the learned advocate appearing for the Indian Oil Corporation.
No, no,
Extremely
nothing.
unfortunate.
No question of
This
instruction.
was the nexus between the private respondent and the IOCL.
Extremely
And
unfortunate.
this is very unfortunate.
IOCL don't have any nexus. They cannot do without any government order
Yes.
or central government order.
Lordship, Lordship.
Now, my lord, in the representation, how this has to be considered by Indian Oil, this contention about my partnership, how Indian
I'm
Oil
not
will
asking
consider.
for any
Let them
partnership
do
to
the
be
arbitration
considered.
proceeding and then they will
No.
apply.
They are not doing with your partnership or your dispute between the partnership. Everything is separate.
Lordship,
They
your Lordship, we
are
appreciate.
applying individually to the IOC
Yes.
whether their matter can be considered or not.
How they will
Your
how they will do
dispute-
that, the part and parcel of the contract.
Your
No,
dispute regarding contract, your dispute regarding
Same
the
petrol pump, same
share
land.
of the petrol
Same
pump,
petrol pump, same land.
you
How?
may
Land
proceed,
belongs to me.
you may proceed against them.
Yes.
You
Lordship,
may proceed against them.
Yes.
your Lordship will appreciate.
You may proceed against
Every
them.
On the
avenues are open to them.
On the last occasion, I have
Cannot stand in the
Private
way of.
before me.
That is what I'm saying. That is
This is
exactly
not
what
a
I'm
private dispute before me.
saying. Yes, kindly have a look. The private dispute is under consideration before my last.
No. These are the facts. Stating the facts, but the prayer is for grant of
Okay.
new license.
Kindly look at the representation.
Lordship, I have only on the last occasion, I have shown to your Lordship that when this dealership agreement was executed, before that, their partnership was
I understand. I know the fact. I
They-
know
they
the
have
fact.
retired.
I know the fact. You have not done anything wrong. They have
I'm not challenging
correctly
the action also.
admitted your stand.
Yes.
Lordship in the guise of representation, their Lordship praying for reappointment, re-engagement. That is not within our party.
Appointment, fresh license. I'm
Fresh-
asking for a
If
fresh
possible.
license individually.
If possible.
That cannot be granted by the IOCL.
Okay. Please take down.
And my lord, I kindly record, my lord, I am stating the preliminary point. Since another writ petition was withdrawn
Yes.
without any leave.
Very well. The instant writ petition was filed
হ্যাঁ, ঠিক আছে, ঠিক
by the petitioner
আছে। এটা কি আমাদের
seeking necessary direction upon the respondent number
Lordship at page number 12, Lordship. Respondent number
you are
Two.
the respondent number 2,
2, 3, 4,
2, 3, 4 মিলন
2, 3, 4 and 5.
2, 3, 4 and 5.
5.
Okay. Seeking direction upon respondent number 2 to 5 to consider the representation of the petitioner at page number
163 মিলন
as at page number 163 of the writ petition being annexed P14
And
and
167, Lordship.
167. There
and
are two representations.
One by the petitioner himself and the other by
The advocate.
163
Two
and
advocate.
169.
167.
167. তাহলে কি বললাম বলুন? 163 and 167.
As well as 169. Oh, 169 is the same.
No, 163 and
Three and
167 of the writ petition. Full stop. learned counsel for the petitioner submits that initially the petitioner was running a petrol pump with the license of the respondent number 2 to 5 with a partnership business through a partnership business
With respondent number 6.
with private respondent number 6. Full stop. The partnership business some dispute arose between the partners. Accordingly, the partnership was terminated.
Not
No,
it was
no,
not
Lordship.
terminated.
No, Lordship.
It was not terminated.
withdraw.
It was arbitration proceeding was still pending. They
was
withdraw.
terminated.
Not ever terminated.
My lord is referring
You left the business.
No, I'm still in the business. They want to avoid me, and without terminating the contract, they applied. Kindly have a look. Kindly have a look. That is why, my lord, how the representation can be considered.
Lordship, there was a
whether they are competent civil
Lordship,
authority.
before the LOI, there was a proposed partnership deed.
Yes, proposed partnership deed was
And,
there.
yes, your Lordship, thereafter,
They issued it.
Partnership is
Yes.
thereafter, there's a dissolution of partnership. And
dissolution partnership was there.
it was there, but after this dissolution, both the partners signed
Yes.
with the dealership appointment agreement.
Okay.
True.
That is true.
Nah, the
Lordship, on finding about these discrepancies, they were asked to show cause, and their show cause are not satisfied. The termination was issued.
Yes. No. Bol. Some dispute arose between the partners. Accordingly, there was a dissolution of partnership.
Lordship, there is
There was a dissolution of partnership.
Well, we are disputing in the arbitration.
Full
That
stop.
is a fault.
Okay, just wait. However, such dissolution of partnership was not intimated to the.
That is actually deed of retirement. They have annexed at page number 26, deed of retirement, not dissolution.
That we
document.
How can he say forced document here and now?
Petitioner annexed the private respondent retired from the partnership at page number 26. But in spite of retirement, this
it was not.
Okay, I heard. Just wait. Not intimated timely to the IOCL. Full stop. And they continued with the business.
Yes.
Full stop. It come to notice to the IOCL regarding the they continued the business. It was come to the fact was come to the knowledge of the IOCL, and they issued a show cause notice.
Yes. Yes.
After receiving the show cause notice, the satisfactory explanation was not satisfactory explanation was not served upon the IOCL. Rather, IOCL was not satisfied with their explanation and was not satisfied with their explanation. Consequently, the IOCL has terminated the license.
Yes.
Dealership.
Of the dealership business.
Yes, Lordship. Of the entire pump, petrol pump business.
Of the
pump business.
Of the pump business of the pump business turn ki bolo?
The petrol pump.
Of business of pump. Full stop. It is the case of the petitioner that since
Lordship,
the
may
business
I
has
be
been
allowed?
stalled,
May be allowed. Challenging the termination, a writ petition was filed.
I know.
And that has reached to the finality.
I
Termination.
since the business of the petrol pump has been stopped. The petrol pump, since the business of the petrol pump has been stopped, the business of the petrol pump has been stopped. The petitioner could not use the land in either way. Full stop. Next para. The petitioner has approached this court in a writ petition challenging the order of termination of the IOC, which was withdrawn by the petitioner himself, and it was dismissed.
Without any leave.
Dismissed as not pressed.
Not pressed.
Simply not. Kindly have a look, page 160.
The order passed in the previous writ
And
petition.
they taken liberty to My lord, petitioner and respondent number to go for the arbitration proceeding.
I choose not to.
The petitioner now approach before this court, showing the order of the state of West Bengal, dated 2nd of July 2024, wherein the state has taken a stand that conversion of land used for the petrol pump is not allowed, will not be allowed. Full stop. On that score, the petitioner has approached this court. No, on that score, the petitioner has approached before the IOCL with the representations so that his dealership may be renewed individually in his name.
Yes.
Full stop. Learned counsel appearing on behalf of the respondent number 225 has raised strong objection and submitted that the IOCL is duty bound by the rule and acts of the central government for establishment or for issuance of any license of petrol pump. The specific notification is required. Specific notification of central government is required for establishing a petrol pump in a particular area or locality within the state of West Bengal. Within the state of West Bengal. So without any order of the competent authority, the respondent number 225 cannot act upon the individual application of the petition.
I am praying for recording my submission that the termination has reached to its final date.
Learned counsel appearing on behalf of the respondent number 225 has submitted that the order of termination passed by the respondent number 225 against the petitioner and against the joint partnership of petitioner and respondent number 6 has attained its finality.
Lordship.
In the petitioner and private respondent number against the joint business of petitioner and private respondent number 6. Business of petitioner and private respondent number 6 has attained its finality. Full stop. Attained its finality. Thus, the matter cannot be revived again. Full stop. Next, learned counsel appearing on behalf of the private respondent number 6 submits that the petitioner cannot file a representation with the authority individually for getting dealership license. Full stop.
Contention of the representation cannot be considered.
He submits that the contents of the representation cannot be considered individually. He further submits that the representation of the petitioner cannot be considered individually. He further submits that there are several disputes between the parties in respect of the dissolution of
There is an arbitration clause.
In respect of dissolution of partnership. Full stop. The petitioner has approached the forum for under the terms of the partnership business, partnership deed, under the terms of the partnership deed to the arbitrator. However,
for appointment of
to the appointment forum,
arbitration withdraw করেছে
deed for to the credit for the appointment of arbitrator,
which has been withdrawn.
Subsequently, the said proceeding was withdrawn by the petitioner itself. He further submits that petitioner himself, learned counsel for the respondent number 6, further submits that the instant writ petition is liable to be dismissed. Liable to be dismissed. For the learned counsel, peruse the writ petition as well as the representation. It is true that the writ petition.
There is no arbitration pending, Lord.
Okay, it is true that the prayer for renewal of dealership by the petitioner to the IOCL is the domain of the IOCL to allow or to reject the same according to the law. Full stop. It appears the petitioner has demonstrated before this court that the land earlier used as a petrol pump cannot be used by the petitioner either way. The petitioner either way in terms of notification dated 2nd July 2024 passed by the government of West Bengal. On that score, he approached the concerned IOCL to consider his representation.
Milord, only one thing, Milord. In my representation, I have said
Alternative
either
prayer.
renew or grant issuance of fresh dealership license individually. Both are my prayer, Milord. Page.
They will decide.
Yes, let them decide.
Lots of Union of India not represented. No, here they are the party here. They are representing, but no representations are made to the Union of India.
Not necessary. You are the competent authority. Okay. Considering the entire circumstances, considering the fact, it appears to me that the prayer of the writ petition is innocuous. Appears to me that the prayer of the writ petition is innocuous. The innocuous, full stop. The petitioner only ask for necessary direction upon the IOCL to consider his representations. Full stop. The dispute between the petitioner and private respondent number 6 cannot be agitated at this stage. Full stop. There are several forum to agitate the disputes. Full stop. Under the above observation, the writ petition is disposed of with a direction to the petitioner to approach the IOCL.
Already approached, Milord.
No, IOCL you again approach.
Achha.
Approach the IOCL with the copy of the representations of page number 163 and 167 of the writ petition.
163.
163 and 167 of the writ petition. On such approach, within 2 weeks from the date of passing of this order. Full stop. On such approach, the IOCL competent authority of the IOCL shall dispose of the representation within 4 weeks thereafter, after giving a reasonable opportunity of being heard to the petitioner. The decision of the IOCL shall be communicated to the petitioner within 2 weeks thereafter. Full stop. Next paragraph. As affidavits are not exchanged between the parties, the allegation raised or made in the writ petition shall be deemed to have been not admitted. Full stop. Next paragraph. Shall be deemed to have been not admitted. Shall be deemed to have been not admitted. Right? Next paragraph. This court has not entered into the merit of this matter. The competent authority of the IOCL is to decide the representation according to the law, without being influenced by any observation passed by this court.
Lordship, one submission, Lordship. By this representation and the reply thereof and the outcome of the representation thereof, they cannot use this as revival of limitation period by virtue of the termination has already been done.
Termination understood what is
Lordship, Lordship.
on oath this statement has been made.
Only one request, where your lordship has contention that this your lordship has not gone into the resolution. Lordship kindly also use that it has been your lordship is not gone into the merit of that particular resolution of that partnership. Resolution of
No. It's
I have not gone to the merit of any matter written in the writ petition. Okay.
Yes. Great. Second,
Material issue, Lordship. For the petition. But this matter, my lord, pertains to that Lordship can recollect. My lord, the petitioner before your Lordship is the contractual assistant professor.
Yes.
So, my lord, she was, my lord, on the maternity leave, and while she made a prayer for extension of such leave, and thereafter, my lord, her leave was time to time extended. And after that, my lord, when she came back and my lord, she wanted to have the benefit of a particular government notification, but she was not given, for which, my lord, she has, my lord, come before this honorable court. So after, my lord, hearing at the motion stage, this honorable court was pleased to, my lord, direct them, the college as well as the university, to file the affidavits. So accordingly, my lord, they have filed the affidavit in opposition. So in the opposition, my lord, they have disclosed that they have already terminated my service. Since I am not there serving in that particular college anymore, so question of getting me, my lord, the benefit of that particular government notification does not come. So I use the affidavit in reply. My lord, my specific case in the affidavit in reply was that notice of termination, maybe I am a contractual employee, notice of termination without communication is non-honest. And if they issue a notice, I have relied upon judgments where it has been specifically stated, held that notice of termination may be issued and may be kept in the drawer of the employer. But unless and until it is delivered and sent to the employee, and he or she has received this, that is not at all effective. So, my lord, another thing, my lord, I was also relying upon the very recent judgment, my lord, which has just come before 10 days back. I just annexed that in my written notes, which says that contractual employee, if he is terminated and his termination is punitive in nature, or my lord, it casts any kind of aspersions on his or her work that he has already continued, and not for his or her dissatisfactory performance, if he or she is terminated, then that has to be done after giving an opportunity to the incumbent. So, my lord, that I have also relied upon. So, my lord, my learned senior friends, my lord, for the college and the university, my lord, they have concluded their argument. And, my lord, their basic bone of contention was that the university, my lord, said that since the approval is the subject matter, my lord, of the DPI, the university will not be able to do that. So, my lord, my answer, straightforward answer to that, my lord, I have never, my lord, prayed for any kind of approval. I only prayed for, my lord, in this writ petition, the benefit of a particular notification, which, my lord, is applicable to the contractual staff, not the approved or something of that sort. So, question of approval does not come. So, my lord, the submission of the university that I am not approved, or the DPI, it is the job of the DPI to approve this thing, my lord, does not hold the ground, because it is not even required. And lastly, my lord, the submission that was forwarded, that I have already addressed to your lordship, about my dismissal, that I am already dismissed. Since I am dismissed, so this kind of notification, my lord, will not be applicable to this particular petitioner. As I've already stated before your lordship, my lord, that will not be, my lord, a ground anymore, since, my lord, admitted position. This is an admitted position that they did not communicate such dismissal order to me. Because in the reply, my lord, they have annexed the resolution in which they have resoluted that they are going to dismiss my service. The resolution, my lord, they have annexed, and in spite of my specific case, my lord, they could not annex anything, or even, my lord, submitted on the bar that I was communicated with any kind of. So they have admitted that it was never communicated to me. So, my lord, this is my written notes, my lord. Lord, you will kindly see, my lord, the judgment, my lord, that I have relied upon, it is also, my lord, appended to this, my lord. I am citation the 2024 SCC Online SC 2282. 2024 SCC Online.
You have
Supreme
cited
Court.
Gorkha
228.
Security Services.
Yes.
2014 9 SCC.
My lord, that is, my lord, previously which I have submitted. Today, my lord, I am submitting this because that I already submitted on the earlier occasions. My lord, this is very new, very recent.
2024 SCC Online.
SCC Online SC 2282. And, my lord, the Kerala High Court, on the earlier occasion, I have addressed to your lordship on the same issue about maternity benefit.
Paragraph.
My lord, the paragraph I have also mentioned and quoted in my written notes. If I can take your lordship only to this, my lord. I tell your lordship, in my written notes, if your lordship kindly sees serial number 8 at page number 9 of my written notes. But the judgments I have quoted, I have mentioned this paragraph exactly, my lord, in the written notes itself. Paragraph number 8, Kerala High Court, my lord, it is mentioned, and paragraph number 13, 16, 17, 18, and 19 are the judgments of the Kerala High Court that I have also quoted in my written notes. And my lord, Maneka Gandhi, I did not, my lord, bother your lordship by giving the copy of this, because lordship knows this only, my lord, for the purpose of giving the proposition that the Audi Alteram Partem and Nemo Judex Causa Sua are the part of the constitution and rule of law. And my lord, about this punity termination, my lord, I have already on the earlier occasion submitted. So this is all, my lord. Lordship will kindly appreciate, and my lord, kindly grant me this benefit.
No, they have raised another point.
Lordship.
Why you were silent since 2017 to 2019?
Yes, yes. My lord, that I have already
You
dealt
have
with.
made a prayer for joining on 11th of December 2019.
My lord. My lord, that I have already, my lord, specifically dealt with in my affidavit in reply. So this is why I have specifically dealt with in my affidavit in reply. So this is why I did not reiterate, my lord, here. My lord, if I just request your lordship, my lord, to see, my lord, the specific paragraph in which, my lord, I have replied to that. My lord, that your lordship will see.
And what is your answer regarding their argument that petitioner had no right to claim?
My lord, that is on the basis that I am already terminated. This is what, my lord, I was just addressing to your lordship. I cannot be said to be terminated. Because, my lord, my termination, even if it is, my lord, if
You
it
are
is
the contractual employee.
Yes.
Contract is year to year.
Yes.
And year complete terminate.
My lord, not if this would have been the case, I would not have any case, my lord. But my lord, they have specifically made their case in the affidavit in opposition by stating that I applied for the childcare leave for the particular period. So, my lord, they ex post facto approved my childcare leave. My lord, I've
extended up to 2017.
17. So that extension of that particular childcare leave was also not communicated to me. But I've stated that thing in my written notes, my lord. The extension, I also did not know that it was extended only up to this such and such period and not extended or expired after that. So if I do not know that up to what time it is extended, not communicated, or it is denied, even if would have been communicated that it is denied, so I would have taken a subsequent step to that effect.
So your argument is that no order
Communication.
communicated to them. That's why you take the
Any order, my lord, any order. This is why, my lord, Maneka Gandhi, I was just addressing to your lordship. Any administrative order, if not communicated, is, my lord, not binding on the incumbent. If it is on the prejudice, my lord, to that particular incumbent. So, my lord, each and every order or resolution, my lord, they have referred that to only in the affidavit in opposition. That is only with respect to the resolution that they have taken. Not even, my lord, they did not say that it was communicated. It is not a case of disputed question. They did not even say that it was communicated. They said that we have taken a resolution. But the resolution does not mean anything if I do not know that. So, my lord, this is my respectful submission that unless they have done this, so, my lord, it could not have been said that I was terminated. And that too, my lord, the recent one, my lord, I was just saying before your lordship, my lord, in the resolution, if your lordship sees once the resolution, my lord, only one line of the resolution, on earlier occasion I submitted to your lordship, one line of the affidavit in opposition of the college.
Respond on 6 and 7.
Lordships. Right. If I request your lordship directly to come to page number 26. But two pages only I'll refer. Achha, first 26, let us see, my lord. Has your lordship got that one? Agenda number 15. The matter regarding the prayer of Mrs. Anindita Maiti, petitioner before your lordship, dated such and such, is thoroughly discussed with references to her previous acts of irresponsibility, misconduct, and delinquence, and subsequent termination of engagement as per decision of such and such, dated on such and such. Presently, the governing body also unanimously continues to previous decision and rejects, nullifies prayer application of Ms. Anindamaith. So I was irresponsible, I was doing misconduct, and I was delinquent. That is the aspersion of the college in their resolution. And that too, this punitive order, my lord, strenuous allegation was never communicated to me. Only on that score, the recent decision of 10 days back, my lord, I handed up to your lordships of the Honorable Supreme Court. Even if an employer, we heard, my lord, it is specifically stated in paragraph 21, even, my lord, may I place paragraph 21 of that judgment once? I have already quoted. My lord, the 2024 SCC online, my lord. My lord, paragraph number 19.
Yes.
The services of the respondent have been determined solely on the ground of misconduct as alleged, but without holding any regular inquiry and affording any opportunity of hearing to him. The termination order has been passed on the basis of some report which probably was not even supplied to the respondent. No show cause notice appears to have been issued to the respondent. Therefore, the order of termination of his services, even if on contractual basis, has been passed on account of alleged misconduct without following the principle of natural justice. The termination order is apparently stigmatic in nature, which could not have been passed without following the principle of natural justice. This is all, my lord, I was trying. I'm so grateful to you, lordship.
Okay.
My lord, each judgments that I have relied upon, my lord, in my written notes, my lord, I specifically quoted that particular portion.
Okay. Please take down. Argument on behalf of the parties concluded, made CAB.
Great.
CAB.
CAB.
That this is my writ petition.
Shuman Honorable. Milord, here the college teachers of the West Bengal, Milord, they are alleging a deprivation of, Milord, a particular scale. Milord, today I'm not well at all. Milord, I'm.
What happened? Tomorrow you are. Yesterday you.
Milord, voice has choked yesterday from yesterday night. It is very
Okay, take rest. Don't worry, take rest.
And it is now almost.
Take rest. Next week? Next week. Not this week. Not this week.
Only 1 second, Milord.
Wednesday 2 p.m.
No, Milord. Milord, 22nd, Milord. There is the only day. No, Milord, 22nd. No, Milord, I will not be here, Milord. 29th possible.
As you wish, 29th, no issue. 29th 2 p.m. 29th 2 p.m. Matter heard in part. Let the matter be adjourned today. Place the matter on 29th January at 2 p.m. As a specially fixed part.
Deeply obliged.
Lord, this is that Levy sugar matter, if your lordship recollects. One file was untraceable and then finally it was found. The difficulty is that whenever we try to do the matter, the other side is not there. There, somebody is here.
Your Lordship, in this matter, I am led by Mr. Dibendranath Rai for senior counsel matter. My Lord, we had filed our application for vacating the interim order earlier. My Lord, and my Lord, court is directed to us, my Lord, affidavit reply in opposition, but our opposition, my Lord, filed, but my Lord, I had no copy, my Lord. Just recently, I engaged the matter, my Lord. Mr. Diendra and me, my Lord. So that's why, my Lord, I'm praying for time, my Lord, some time, my Lord, 1 week time, my Lord.
Now, this matter is running in the list for quite a few days.
My Lord.
Under the
I know, my Lord.
under the hearing.
Yes, my Lord.
So what you want now?
1 week time, my Lord.
For what?
For my senior ground. See, my Lord, senior has not come to due to some personal difficulty, my Lord.
You take note.
Yes.
Take a pen and paper. Take note. I am starting let's start the argument first. You take note. You can come next day. Okay?
Yes.
You take note.
Very well. My Lord, kindly take first WCR. My Lord, in those days, it is to be called CR. CR number 4661 of 1984. My Lord, they are different years, challenges to different years of price fixation. Well, kindly take this one first. Abhi bhi chocolate de rahe hain.
Okay. 4661.
Yes, my Lord. Kindly give me a moment. CO season 5041. Since Vishnu Sugar. Take a look. Vishnu Sugar. Kindly give me a moment now. Stick out my. Yes, I've got it. Yes, yes. Well, I'll give your lordship a brief background of what is the scope of challenge. Well, the petitioner of your lordship is a company which is engaged in the business of manufacturing of sugar.
Yes.
So they have a sugar mill.
Sugar mill.
Sugar mill. Well, this factory was originally installed in the year 1932. And it was registered under the Industries Development and Regulation Act of 1951. Now, these are undisputed fact. Well, in the year 1961, the crushing capacity of my factory was 800 metric ton. Now, my lord, here I wish to, my lord, trouble your lordship with first one document. Lord, kindly take the trouble of coming to page 47. Here your lordship will find, well, this is one of the principal points that will come up for consideration. Kindly take page 47 once. An application dated such and such for license have been received from Vishnu Sugar, which is the petitioner of your lordship, for effecting a substantial expansion to their existing industrial undertaking at such and such. Then, my lord, kindly see the next sentence. In exercise of powers conferred under Rule 15O of the said rules, well, the rules your lordship will find on just before that, of the registration and licensing of industrial undertaking rules of 1952. So the application was made under that rule.
Yes.
So in exercise of powers under such and such of the said rules, hereby grant this license to effect the substantial expansion to the existing industrial undertaking. Now, my lord, if your lordship kindly turn to the relevant page, what happened is, my lord, our expansion from where to where we expanded. Well, basically what happened is initially we had a crushing capacity of 800. Well, by this order, I was allowed to expand it to 1200 metric ton per year. Per year? No,
Per day.
Per day. I stand corrected.
Paragraph 5.
Yes, man, grateful. The import of raw materials will be regulated by such and such. That in force, I am reading para 5, which your lordship has been pleased to point out. The industrial undertaking or is such and such concern, code license, such and such established. Now, if your lordship will see, I think possibly it's para 3.
Para 3.
On the top of page 48. Now, there are two paginations. One is typed 48, 49. So kindly take internal page 2 of this document. On top, your lordship will see para 3.
Yes.
Yes. Kindly see the industrial undertaking shall be expanded so as to increase its crushing capacity by 400 tons of sugarcane per day, and its capacity after substantial expansion has been effected shall be 1200 metric ton of sugar per day.
Yes.
So I was 800, expanded by 400. So from 800, I became 1200. Now, after this, your lordship will see, I also applied for one further extension, which was rejected. Allow me to trouble your lordship with that once, because I remained at 1200. My expansion after 1200 was not allowed. So I need to show your lordship that. Your lordship will kindly take. Yes, page 64. Madam. Kindly come to page 64. Now, I had once again applied for further extension, further expansion. I stand correct.
Yes.
So that expansion application of mine was rejected in 1977. That's at page 64. Now, that kindly have a look at.
Page 47, your capacity was expanded.
Expanded from 8 to 12.
8 to 1200 ton.
Yes, per day.
Per day.
And thereafter, I once again applied.
That is page?
Page 64.
Page 64.
And that subsequent expansion application was rejected, which is at 64. Well, this would be a letter of 10th May 1977.
Yes.
Yes. One kindly see the subject ones. Application for a license under the Industries Development and Regulation Act 1951 for effecting substantial expansion of the existing undertaking for the manufacture of sugar falling under Schedule Industries number 25. Now, my lord, without troubling your lordship much, my lord, I'll just indicate what is relevant. My lord, kindly come to the name of the unit your lordship will find at page 66, Vishnu Sugar. And your lordship may also consider the first paragraph of this letter or this communication. And then, my lord, I'll take your lordship to the relevant portion. It starts, the first para says, I am directed to refer to your above application and to say that the performance of your factory during the last 5 seasons has not been satisfactory. Moreover, the availability of adequate sugarcane at present and the future potential are not encouraging. Then what happens is, your lordship will kindly take page 66. Your lordship will see the first name and top of page 66 is Vishnu Sugar, which is the petitioner of your lordship. And then, my lord, kindly come to page 6, the next page at page 67, internal, possibly internal page 2 of this letter.
Yes.
But actually, I'll tell your lordship, this annexure A, the first page of this letter 64 and the second page of that letter continues at 67. The 2 pages which is at 65 and 66 should have come later, but by mistake they have come before, because it's a continuation. Page 64, page 67 is the continuation of 64. If your lordship reads the letter from the bottom of page 64, the last 3 words are final orders will. Then if your lordship comes to 67, it's a continuation. Be passed after full consideration of the points urged.
No, in my copy it is correct.
It's correct.
Yes. In my copy it is correct. 64, thereafter 65.
And it's a continuation of the same letter.
Yes, sir.
Yeah, then your lordship is, of course, fortunate. We are not. Then it says, my lord,
After 65, there are appendixes.
Yes, mine has come earlier.
Appendix A.
Correct.
And conclusion of appendix is 67.
Correct. Mine is all.
67 is West Bengal plenary roller.
Yes. Mine has become reverse.
Okay.
But this is what happens when you have a writ petition which is about 40 years old.
Yes.
Well, it says, be passed after full consideration of the points urged. Then, if no representation is received from you, your application for license will stand finally rejected at the end of 3 weeks at the date of issue of this letter. You are also further requested to address all
You
your
are reading
internal page 2, page 65.
Okay. You are further requested to address all the future
Yes.
correspondence. Okay.
So if your lordship will see the subject says expansion.
Yes.
So my application for expansion by this communication of May 1977 stood rejected. And they said that if no further representation is received within 3 weeks,
Your
then
application for license will be stand finally
rejected. So no further communication was made by me. So my further expansion application stood rejected. Now, if your lordship will kindly come to the next aspect of the challenge, my lord, in 1966, which would be, my lord, page 53. This is the press note. This is by which the government of India's liberalization policy in 1966.
Yes. 27th October 1966.
Yes. This is your lordship will see Ministry of Industries. This is how in those days, the government was existing industrial undertakings were permitted to expand by 25% without license.
Yes.
Now, my lord, your lordship will kindly see. So our capacity remained at 1200 metric ton per day. I showed your lordship the previous.
Yes.
That is my crushing capacity. And it did not exceed beyond that, which your lordship will be, which is evident from page 63. So, my lord, from 1969-70 till 82-83, my crushing capacity remained at 1200 metric ton per day. So, this is an undisputed fact.
Okay.
So, not denied by them even in their opposition. Now, my lord, comes the sugarcane or the sugar price determination order. Now, my lord, kindly take this once, the 1980 sugar determination order. My lord, this was issued by Government of India under Section 3, subsection 3C of the Essential Commodities Act, where your lordship is aware, my lord, in those days, levy sugar price. So you have to only supply to government, and government based on the unit will give you the price.
Yes.
Now, my lord, here what happened is the criteria that the government made was of two categories. My lord, one was a efficient unit, the other was a less efficient unit. So the less efficient units were put into one category, and the efficient units were put into another category. And the price which the government was paying was based on whether you are a less efficient or an efficient unit. Surprisingly, my lord, what happened, or that's the way the policy was of the government in those days, for less efficient unit, those units, those sugarcane mills, those who were less efficient, they were paid more.
They are paid more.
More.
Okay.
And the efficient units were paid less. Well, the whole logic, as I understood, the policy is based on the cost of production.
Yes.
Because the modern units, the cost of production in modern units were much less. So they were getting much less from the government. Their production, so the profit margin remained the same. But for those units which were less efficient, old, like I was a 1932 wheel factory, so I was using old machines. So for less efficient units, the price was more. Now, my lord, then happened the classification. Now, the government also made policies that what would be the basis of classifying. How would you classify? I am a factory. In those days, there were mainly factories in Bihar, UP. There were few in Bengal as well, mainly in Uttar Pradesh. Now, question is, how would you classify the unit? So there must be a criteria on the basis of which you will come to a conclusion that this unit is a efficient or a non-efficient unit. So that policy was also made. So our case is based on the policy and based on the guidelines that the ministry has issued from time to time, and the press note and the agricultural minister's statement made in the parliament, we fall into the less efficient unit. And we have been paid by the government of India based on a less efficient unit. Subsequently, what happened? The government amended that and said that no, you are not a less efficient, but you are an efficient unit. That was the subject matter of challenge.
What is the parameter of less
Yes,
efficient and
yes,
efficient
yes,
unit?
yes, yes. That parameter, your lordship will see from the policy. Now, let us kindly come to the policy. Now, my lord, the criteria for determining was done by the high-level committee.
Yes.
Yes, my lord. Kindly come to first page 68. Well, I just hope my brief tallies with your lordships, because all these briefs were reconstructed over the years. Previously, somebody else was appearing. Now, my lord, kindly take page 68 once. My lord, this is a communication of 26th November 1980.
Yes.
My lord, kindly see, it is a circular of the government. It says major recommendations of the high-level committee.
Yes.
I think this is a typographical error. In those days, your lordship knows everything was typed, and everything was at the hands of the typists. No possibility of corrections to be made. So now, my lord, kindly see the first word is the incorrect word. I am reproducting. It should be reproducing. Here under, for your information, question number 46 and the answer given by the Ministry of Agriculture in the Lok Sabha on the 17th of November 1980 regarding the above. Now, my lordship will see the above. Above is major recommendations of the high level committee.
Yes.
So now your lordship will kindly take question 46, which is this is what the Secretary General has to say. Now kindly see, this is the minister's recommendation that was made. Whether government have received the report of sugar prices from committee appointed for the purpose, headed by the chairman of the Bureau of Industrial Cost and Prices. Yes. What are the major recommendations of the committee? The major recommendation made by the committee are indicated below. For the purpose of ascertaining the country, now, my lord, I'll not trouble your lordship, my lord. Kindly come to E at page 69. Paragraph E. E for elephant.
Yes.
Yes. There should be a two-tier levy prices in each zone. That is, one for the efficient bracket, average and above average, and the other for less efficient units. It has gone down as loss, it should be less.
Yes.
The two criteria for determining the less efficient units are A, capacity being well, kindly see, the first criteria was capacity being less than 1250 metric tons of cane sugar, cane crush, I stand corrected. Capacity being less than 1260, 1250.
1250 tons of cane
crush per day. Now, my lord, if your lordship recalls, my cane crushing capacity was 1200. So I am less than 1250. So this is the first category or the first criteria which I fulfilled. Then B says the age of the plant over 25 years. Now I am a plant of 1932. So I am naturally much over 25 years. This is intended to benefit the weaker units to withstand the competition with efficient units and to improve their management and operational efficiency. This was the logic for giving more to the less efficient unit, because first blush logic says that you're giving more to less, and those who are better, you're giving them less. So to make those lesser units more competitive, and at that time we were in the industrial growth. Initially, industrial policy of the government was to, we were stabilizing our economy in those days in the 60s and 80s. So this was the policy. Thereafter, my lord, your lordship will kindly take. So this was the criteria. Now, my lord, your lordship will kindly take. So based on this, where are these pages? 72. Now, my lord, first kindly come to the next page, 72. Immediately thereafter, your lordship kindly comes to 71. Next page.
Yes.
My lord, we are writing to the Joint Secretary of Ministry of Agriculture. Now, if your lordship will say, we invite your kind attention to the submission made by us on such and such 81 for restoring our Gopalganj factory as such in Schedule 6. Now, my lord, your lordship will kindly make a note. Schedule Roman 6 is, let me just clarify before I make that submission, my lord. Which is less efficient and which is efficient? Yes, 6 is less efficient. Roman 6 is less efficient and 5 is efficient. So, my lord, what I am saying is that we have to invite your kind attention to the submission made by us to you on 7th January 81 for restoring our Gopalganj factory in Schedule 6.
What schedule?
Schedule 6.
Where
Now,
is the schedule?
No, I'll tell your lordship the schedule. I must first show your lordship the schedule before I take your lordship to who comes into that schedule. Allow me to show your lordship where that schedule is. And lordship kindly gives, he says at page 87. If my learned friend is correct, I'll thank him. No, he's not correct. 87. देखो तो एक बार बाबा। ও পেজিং নেট মিলছে না, সর্বনাশ করেছে।
Don't match the paging.
Don't match the page. দারুণ বলেছো। Schedule 2, my lord. Mine is schedule 2. I don't know how he's saying. If your lordship will see the gazette notification, this is of 84 though. No, the 84, if your lordship kindly comes to page 80. Because there has been much before that. That's what I wanted to show, my lord. There was previous writ petitions. Interim orders are a part of my writ petition. That's why I wanted to show your lordship the 81. What happened in 81?
Yes.
Because 84 came much later. 81 only I was classified and it was under challenge before this court. Now, my lord, your lordship will kindly see liberalization policy. Kindly gives me a moment. I'll just give your lordship the Government of India Ministry of Finance.
I have schedule 4
I'll just give your lordship the
at page
1981.
91.
Yes.
92 is schedule 5.
Yes. No, my lord, those are for 1984, year 1983, 84, which is under challenge now. So I'll show your lordship what happened in 81. If your lordship will kindly take that page 70, I was showing your lordship page 71.
Yes.
68 is that categorization by the ministry. 71, I write that letter of 1940. Then, if I may just trouble your lordship once, that if you kindly see, I'll show your lordship the categorization. Kindly take my lord page 71 towards the bottom of page 71. That same letter.
Yes.
We have mentioned in the submission made to you on such and such 1981 that we were permitted to expand capacity from 800 to 1200 by Government of India, Ministry of Commerce, license number such and such, VDA letter number such and such, inter alia permitting addition of the third roller mill of such and such to achieve the expansion in a capacity of 1200 ton per day. The such and such addition of the mill could not be made till the date, and the same mill plant since inception of the plant is continuing without any addition whatsoever. On going through the form number such and such for the year 1979-80 enclosed herewith, you will find that the sole replacement of the balancing equipment, then it
Some replacement of balancing equipments have taken place.
Yes, yes. So, then if your lordship will kindly come to Roman 6 at page 71b.
Yes.
In this connection, you will kindly note that under your order number such and such, our factory was rightly included in Schedule 6. Initially, I was included in Schedule 6. But again, VDA order dated January 81, your factory, our factory has been incorrectly deleted from the above schedule without giving us an opportunity to be heard. As per estimates available, our factory is likely to be closed for some such and such, middle of February, such and such. Now, kindly see the quoted portion. In this connection, we also sent you a telegram reading such and such. Regarding our submission for inclusion in Schedule 6 of the sugar price determination order, our crushing operation for 80-81 season is expected to continue only till the middle of February. In the event of spot inspection, such and such desired, then this is what I write. Then what happens is the next page, kindly come to the next page. This is also my communication of January 81 to them. If my lord will kindly now turn to page 85. That same letter which I have shown your lordship earlier, this formed a part of my response to them. Now, my lord, kindly come to page 72, which is the order passed in my first challenge in the writ petition before this court in 1981. Now, when what they did is, initially they categorized me in Schedule 6. Now, when they changed my categorization from 6 to 5, I challenged it in a writ petition. I said that I squarely fall within Schedule 6. That is less efficient unit. You could not have changed me. Now, I'll kindly take page 72.
1 to 5 schedule is the sufficient unit.
No, my lord, I think Schedule 6 is less efficient and Schedule 5 is efficient. And my lord, if your lordship will see, Schedule 5. Actually, it is there. The 81 is there in the other writ. I'll show your lordship why.
Yes.
Kindly take, my lord, page 72 once.
72, yes.
Here your lordship will see this is an interim order passed by this court in my writ petition challenging the 81 classification. Your lordship will see the right column is the order. Upon hearing a petition of Vishnu Sugar and affidavit verifying such and the exhibit such and such, and upon hearing Dr. Pal, this is Dr. Devi Pal, it is ordered that a rule to issue calling upon the opposite parties to show cause why a writ in the nature of mandamus should not be issued, directing the opposite parties to act. Directing the opposite parties to act as referred to in prayer A and B of the petition, or why a writ in the nature of prohibition should not be issued, commanding the opposite party to refrain from giving effect to the second amendment. Now, the second amendment was by which I was changed from 6 to 5. Order as complained in prayer D of the petition as to why a writ in the nature of certiorari should not be issued, such and such, such and such. Now, if your lordship will kindly turn to the next page, the rule is made returnable immediately after that. There will be an interim order in terms of prayer F and G. So, lordship found that?
Yes.
F and G of the petition subject to the condition that the petitioner number 1 will go on supplying sugar to the respondents on the basis that its name appears in Schedule 6. In terms of the order dated 15 December 1980. This interim order will remain in force for a period of 2 weeks with liberty to apply for extension. Now, my lord, this prayer F and G, I'll just give you, lordship, the 81 writ prayers. 13574. Well, that is also a part of this set of writ petitions. It is there, a part of the set of writ petitions. 13574
of 1981.
13574 of 1981. There's another, I'll just show your lordship there your lordship will find the schedule. Writ ache?
Page 36. हाँ, reconstructed.
हाँ, ये
Page
दो ना
36.
हमारा काम हमारा আছে
Page?
Page is
36.
36.
At bottom is the prayer F, which Mr. Bose is referring to.
আমার কাছে নেই, সব 83
Prayer F and G.
F and G.
Injunction, respondent.
From giving effect or taking any steps or further steps in furtherance to the said 81-82 price determination order. Schedule. Here your lordship will find that schedule. The schedule 6 and schedule.
Page 62 is the schedule. The government order.
Page
62, my lord. The same writ petition.
Now, this is the 81 price determination order. Here your lordship will find third page scheduled. Your lordship, I'll show your lordship, my lord. If your lordship will see here, page 67 starts schedule 2. Then your lordship will see 3, 4, 6 kota hai. 5, 5.
So here, if you took the two here, so explanation was if schedule 1, 2, 3 will be in which category, 4 in which category, this time different schedules will be.
If your lordship takes the explanation at page 64, that has been the same for every year. Page 64, internal page 3, running page 64 of this 81 rate, your lordship will find an explanation.
Yes.
So it says the prices specified in columns 2 to 7, that is the prices that will be paid by the government to the sugar mills of schedule 1, 2 and 3 and 4 aforesaid do not include such and such. Then if your lordship kindly turn to the next page, prices specified in such and such, then your lordship see column 2 is with respect to loading charges, separate categories are being made. Now if your lordship turns to the next page, your lordship will find schedule 1 first, then schedule 2, and the name of the mills are given zone wise. And there your lordship will come. Our problem is 5 and 6. If your lordship will kindly come to Bihar, this would be running page. All of them are in Uttar Pradesh. If your lordship kindly turns to page 75. If your lordship will see North Bihar zone, it starts at page 74. And if your lordship turns to page 75, the last serial number is 11, Vishnu Sugar Mills, which is the petitioner.
Yes.
So I was categorized in schedule 5 instead of schedule 6. And if your lordship will see where schedule 6 mills, the mills categorized under schedule 6, they must be starting. So this was the challenge in the previous writ petition, that why did you do that? And you could not have done that. That's arbitrary. This your lordship will find from page 87, schedule 6. The schedule 6 units starts from page 87. Kindly take the list, my lord. Page 87. This will become absolutely become clear.
North Bihar, 11 is the Vishnu Sugar.
Yes. So I was in schedule 5. They did that in the price determination order. Now, if your lordship take page 57, it's a continuation of the same price determination order. All over the country, this notification is made for all the units who will get how much. Now, kindly take 57, which is a continuation of the same document.
87.
87. Schedule 6.
Yes.
List of vacuum pan sugar factories erected, my lord, kindly make a note, prior to the first day of 1953 or 55, whichever way, because I was erected in 1932 and have a licensed daily cane crushing capacity of less than 1250. So there are 3 categories: less than 1250, less than 1250 ton, and have also not expanded the capacity of 12 metric ton, or liberalized licensing policy, less than 12 metric ton, have not crushed 12 metric ton or more during each of the preceding 5 years. So our contention is that we fall under this category. But your lordship will see there are several factories mentioned here, but my name is not here. My name has gone to 5. So this is my challenge. This was my challenge in this 1981 writ petition. Now, if your lordship will come to that interim order which I was showing in the present writ petition, this interim order was passed in this 81 writ petition. Your lordship can find the number of the writ petition also at page 72. Your lordship will see Vishnu Sugar versus such and such. This is what we have, my lord. This is the interim order that was passed in 1981. Now, if your lordship will kindly turn to the next page, 76.
Yes.
Again, Dr. Devipal, there will be a civil order restraining the respondents from giving any effect to the order putting the petitioner in Schedule 5 until further orders of this court. I make it clear that this order is duly confined to the present petitioner. Now, kindly see the top, my lord. This is in respect of the other sugar mill. Now, if your lordship will see, page 90, this is 93. Possibly it's 93 because I don't have a, this is an order of Justice Manjula Bose. If your lordship will see, it's at possibly page 93. This is also Vishnu Sugar. The both matters were taken together, Riga Sugar and Vishnu Sugar. Here, an order was passed at page 93. See, your lordship will find that page 93, there's an order. Page 77. Can't be.
Page 93, I don't
No,
know.
93, I'm sorry, man. Possibly it will be 77 of your lordship's. 77. 77.
77.
Yes, man.
And
Kindly
order dated 29th of
My
December
lord.
81.
81. The petitioners will keep on supplying to the respondents the levy sugar on the basis that their names appear in Schedule 6 until further orders of this court, but this order is without prejudice to the rights and contentions of the parties. Meanwhile, the petitioners are directed to keep the differential amount between Schedule 5 and 6 in a separate account because I was receiving more. So that whatever I have received in excess from 5 and 6, separate account with them until further orders of this court and subject to final determination of the writ petition. So, my lord, they have been kept separately. Subsequent orders are there, my lord. They have been initially kept separately. Then I gave a bank guarantee. Then my lord, kindly come to page 78.
These are all interim orders.
Yes. Absolutely. Now, my lord, kindly take page 80. 80. This is the order which is the subject matter of challenge in the present writ. 84.
80.
80. This is the order of 11 January 1984. This is the order means this is the sugar price determination order 1984. The relevant portion your lordship will find my name. I have once again been categorized in Schedule 6. My God, it's a blank exam. Allow me 1 minute, my lord. Just see which is the page number. North Bihar. $122. Will your lordship kindly take 96 months? 96, if your lordship takes, your lordship will find Vishnu Sugar Mills, serial 11.
Vishnu Sugar Mills, serial 11.
Yes.
It is within 6,
Within,
5 or 6.
this is 6. Let's check. Lordship will kindly give us a moment. This is schedule. My
North Bihar, schedule 5.
schedule 5 possible. Must be. That's why the challenge. So yes, schedule 5. My papers are wholly illegible, so I've not been able to assist your lordship on this. No, that is possibly the reason why the challenge. And then, my lord, an interim order is passed in this writ petition as well.
Okay. Yes.
Schedule 5.
Schedule 5. Schedule 6 start 119.
1 month. So it should logically be in schedule 5.
Yes.
Well, then at page 133, there is a communication from the government of 1984. In exercise of powers conferred under clause such and such.
You reading page?
My lord, page 133.
133. Yes. (1984).
Yes.
10th January.
Yes. If your lordship kindly comes to the direction part, it's so illegible. In exercise the powers conferred under clause such and such of the Levy Sugar Control Order of 1979, note and notification of the Government of India, Ministry of Agriculture, such and such, Director, the Ministry of Food and Supplies, hereby direct Vishnu Sugar of such and such shall sell from Vishnu Sugar Limited, Vishnu Sugar Mill, Gopalganj, on receipt of this direction, (170.7 decimals) something tons of levy sugar out of the production of the year 1983-84 to Food Corporation of India and their nominees, and where such nominees such and such, quality of levy sugar. Then your lordship will see
subject to the following conditions.
yes. Yeah, this is for that period where I will supply. I was required to supply by this order to Food Corporation of India.
Yes.
Yes. Now, my lord, your lordship will see page 137. Kindly take this, my lord, once. Apropos to your letter dated such and such, 83, on the above quoted subject, I am directed to inform you that your case has been duly examined and it is regretted that you are not eligible for grant of an additional levy sugar price of 26 rupees per quintal as available to sugar factories included in Schedule 6 of the sugar price determination for 80 to 83 production order of 1983. So this is my subject matter of challenge, this refusal. And then the writ petition. And if your lordship will see the prayers of the writ petition, this is what is under challenge in my writ petition. Possibly the prayers starts from page 41.
Yes.
This is my challenge. Now the question before your lordship is that whether this determination of my factory in Schedule 5 is that correct, arbitrary, unconstitutional, or this is basically a 19(1)(f) and 19(1)(g). So I say that I am entitled to more because I'm a less efficient unit. You have wrongly categorized me in Schedule 5. So this is the challenge. Now, my lord, how to determine this challenge, my lord, there are a few judgments which I need to show your lordship, that's all, which says that this is what is the basis of classification. And there are two bases which has been given. One is crushing capacity,
Yes.
and the other is age.
Age.
There is nothing, there is no third factor. So I say that I qualify in both. My crushing capacity is less and my age is more.
More than 30.
More than 30. So then how do you classify me in Schedule 5? No answer to that. Now, these are my challenge. There are certain judgments of the Delhi High Court, and especially a division bench judgment of the Delhi High Court in Godavari. Well, we have not been able to trace that. It was in our brief, but there's one judgment called Malaprabha. There's one judgment called Godavari, and there is one single judge judgment which follows Godavari. So this is basically what it is. So this is the limited challenge. Well, if your lordship kindly fixes it on any other day, we will complete it by schedule and then they can respond.
Whether you bring out the judgments?
Yes. We don't have that. We've not been. These are the three judgments. Now, I can't hand over to your lordship the judgment that I have. That's a white paper. So the authenticated judgment I need to give to your lordship. So first you take it out. Because I cannot not been able to promise your lordship that I can give your lordship the judgment today or tomorrow. Till I take it out and till it comes to my hand. Give me that white which refers to Godavari.
Okay.
There is a Delhi High Court judgment which follows Godavari. But that's a that's an unauthenticated copy. That is a part of my brief also.
Matter of definition.
Hmm.
It's not authentic. It's in the matter of Vishnu sugar only.
So this is the judgment that we have. This refers to Godavari sugar mills.
Yes.
So this is the judgment.
Unreported.
This is unreported. We've taken it out. আমরা বার করে দেবো তোমার। Your Lordship will find there's a reference to Godavari and towards the bottom of that page there's one reference to Malaprabha. These are the two judgments that we need to show Your Lordship.
Godavari Sugar Mills Limited versus Union of India and another.
Yes.
And they have not.
This is one, and the other towards the bottom of that page, Your Lordship will see there is a reference of another judgment called Malaprabha. So these are the two judgments we need to come back to Your Lordship with. Then our arguments will be complete. We have nothing else to submit.
এটুকু judgment বের করতে পারবো? এটুকু judgment, এটা বের করতে পারবো। SCC আমরা।
We will also try, madam, because these are not available in SCC online. And since they are a judgment of 80s, it is not there in that new website Justice Chandrachud had. I mean, he inaugurated that. That what is that called? The Supreme Court, the site where all the old judgments are being Supreme Digital. That they're all been uploaded.
In
We've not
AIR, it would be there, I think.
not there. It's not there. We'll give copy. Kindly
versus Union of India. At Secretary February 7.
Karnataka.
Karnataka.
We'll come back with Your Lordship with the Delhi High Court Division.
Okay.
Any day convenient to Your Lordship.
Next Wednesday.
Very well.
22nd.
Next Wednesday. Well.
Argument on behalf of the parties are in person. Let the matter
after 28th month.
After 20th.
22nd to
At the 22nd, actually, the 20th, 40.
After 28.
28.
28, yes.
28.
28.
28, that means not this month. Why?
He is not available.
Then come on 29th.
Yes.
29th.
At 2 p.m.
January.
Jagriti fixed.
At 2 p.m.
At 2 p.m. Your Lordship on 29th has fixed the other matter at 2 p.m. There's another matter before this which Your Lordship was pleased to fix on the 29th. I think.
Yes, I have fixed one matter.
Yes. One more matter.
I usually fix those matters. It will be second matter. No issue.
Actually, when at 29th, I have a fixed matter at 2 p.m. Both 28th and 29th are continued.
Very well, then come on 5th of February.
Sir, may I come back on 22nd? I complete.
But my lord, I was not available. Problem difficult.
Very well, come on 5th.
5th.
5th of February.
5th. Very
No.
Wait.
Thank you. Thank you.
I am for the petition amendment. There is a specific direction to file a report, affidavit. No report has been filed. Your Lordship may remember this is a matter. I am a wholesaler. Your Lordship knows, so far the urban areas of the state is concerned, under urban control order, instead of distributor is the wholesaler. what happened in this case, my lord? On 6th of December 2018, a suspension order has been issued. All the areas, that is, I am running the business in respect of, my lord, Kamarhati and Boranagar under Damdam Vidhannagar sub-area, and Amha Street, Bowbajar, Maniktola 2 under sub-area Kolkata North. Subsequently, I preferred an appeal, and the appellate authority, my lord, quashed the order of suspension. But this Amar Street, Borobajar and Maniktola 2 area has been dealing from me. When I have been suspended, according to the procedure, all dealers have been tagged with the nearby distributor or the wholesaler rather. So far, my lord, the Kamarhati and Boranagar is concerned. Subsequently, I return back these areas. There is no dispute. So far, Amar Street, Bowbajar and Maniktola 2 sub-area is concerned, the goods which are lying with me, that has been lifted by the other distributor according to the procedure, 50%. This is in 2018. Time and again, I requested the director as also to the deputy director, please leave this good. It cannot be continued because I have lost this area. I have to pay the go down charge every month 1 lakh. No steps have been taken. From 2018 to 2020, no steps. All documents I have annexed. In 2020, they written a letter that these are the dues. I immediately opposed the same. It cannot be, it is not my fault. I have given the go down to the landowner, being a tenant. Then 22, they asked me to appear for hearing. I appeared. No steps have been taken, no decision has been taken. Now 2023, after 5 years, they made a huge demand of 76 lakhs. 76 lakhs? 71 lakhs. I told them, though, it is not my fault. You cannot demand this money. After 5 years, all goods have been perishable goods. It has been destroyed. Each and every 2 months, I wrote the letter, please leave these goods. From 2018. You didn't give reply even a single letter. Now, 2024, what they have started, entire bill amount they have deducted from me. The moment I submitting the bill, all amount are being deducted. On last occasion, your lordship passed an order directing the state authorities to make payment of 2 months commission, that is June and July. Since then, there is a direction, upon direction, so many direction, no affidavit has yet been filed. I can say, my lord, so far this case is concerned, they have nothing to say. They have nothing to say. And from August, September, October, November, December, I could not raise my bills. The moment I shall raise the bills, they will deduct the entire amount. Today, I am paying before lordship, subject to lordship council. Let them file, let them take adjournment, file their affidavit. In the meantime, your lordship kindly direct them to make payment of this 5 months commission.
No, I can dispose of this matter today also.
Yes.
See, may I have a chance to deal with these allegations? While my lord, he come with an affidavit, my lord. If 7 days time will come, my lord.
But payments must be made, my lord. I am just starving.
He has placed all the documents.
All documents I have annexed.
Written the letters. Please leave the articles.
Everything is there. Everything is there.
You have not lifted the articles. What is your answer now?
As I understood, my lord, they are not in a position to give any reply.
And what are you saying? 50%.
Now they are saying they will deduct 50%. I have been compelled to make an assertion that I shall give 10% also. Although it is not my duty. But because my kindly considers, my lord, only on the basis of commission, all laborers I am engaging, all infrastructure, every month 1 lakh rupees tenancy rent for go down.
Okay.
So give me 10 days time, so I'll come with an affidavit, my lord. Because there's a two.
Mr. Church's voice is very low. Abnormally.
Because, my lord, the documents is in the two directors, my lord. For this reason, I am facing some problems collecting the documents, lord. So give some time, I'll come with a document. Because there's a Jodasako and also.
At their proposal, if the matter is disposed of, it would be better for you. Otherwise, if I going to determine the matter on whose fault the huge money, government money was such a way.
Only to, my lord, save the skin of the officials. This thing is going on.
My lord,
Because
there's
some
a
deputy director, there are two direct, initially, my lord, there are one directorate. Now it
71
has,
lakhs, my lord. So far, there is a pecuniary
Yes,
matter is concerned. There's a
yes,
huge,
pecuniary liability is there. If I going to dispose of the writ,
my lords,
according to
what
the prayer of the petitioner,
what is the
then there would be other
what is fallen, my lords, my
subsequent
lords,
facts.
my lords would send it back to the department for consideration. What is my lord's desires, my lord?
My desire is 50% and go to pay.
That will I'll come with an instruction, my lord. Without
but kindly come to page 51, just for a moment. 50%, 51 page.
15%.
Kindly turn to page 51, just for a moment. Just one document.
According to their prayer, they wanted to give 10%. I can only
15.
15%.
My lord. 51, kindly turn up, my lord.
Yes.
This is the letter of 14th December 2022. I have been asked to appear before the Deputy Director on 19th December. Till today, no decision. My learned friend is seeking for an award for fresh consideration. Till today, no decision.
My lord,
December 2022.
if my lord directs this, they will take the decision on the basis of these letters that will pending before the director, my lord.
No, that is they have you have submitted a report that 50% can be deducted.
Make it, my lord, 15%. I am not arguing with lordship.
1.5.
And matter may be pending. If they ultimately succeed, entire amount, because money is with them.
No, I shall dispose of the matter by 1.5. Otherwise, the liability would be raised against any
My
officers.
predicament, lordship, kindly understand my predicament also. There's a revenue matter, lordship. This
Yes,
huge amount.
revenue matter is there. That's why I am asking that's why I am pass the order that whether it is agreeable for the department, the 10%, the proposal of the petitioner.
Yes,
can be
that's one of the order.
I know the liability. If the order of the court is there, there is no such embargo upon the officers. Otherwise, if the matter is dealt with, there would be otherwise.
After affidavit, that will be
Yes.
more dangerous.
More dangerous for the officers.
Lordship, kindly keep it not today, my lord. I'll come with an instruction.
You take proper instruction, and I have already disclosed my mind. Okay.
15% করে না, তাতে তো লাভ হতো না।
Otherwise, the responsibility will be fixed against any officers.
May I suggest on the subject to your lordship approval? Your lordship may keep the matter pending
Yes, I
after giving direction for filing affidavits, because let them satisfy your lordship that these are the reasons. In the meantime, my lord, so far my 5 months is concerned, 15% may be deducted there. Because I am not compelled to give any percentage, but I am accepting your lordship views. 15% let them deduct from each and every bill. Direction may be given for filing affidavits. Time may be extended and matter may be adjudicated. Because I want this 50% also. And these are hard in part matter.
Lordship, these are, my lord, 15% of every month, my lord.
Every month.
Every month. Calculated recovery for the entire 71.
Yes, every month. All recovery.
I'll come with an
instruction. And now, in the mean, abar instruction কি আছে? তোকে কি instruction দিয়েছে আমি জানি. I know.
Today is the Wednesday. Tomorrow and Friday is the other matter.
Keep it on Monday, my lord. I'll come, my lord.
Okay, come on Monday. I will dispose of the matter. I shall dispose of the matter.
I'll come.
Monday to be mentioned.
Monday to be mentioned.
At 10:30.
Yes.
Grateful, my lord.
Monday to be mentioned 10:30.
Please take down. Mr. HON'BLE Charge, learned counsel appearing on behalf of the state of six
I led by
accommodation.
I led by Miss Sinha, my lord.
Okay.
Sonal
Mr. HON'BLE Charge, led by Miss Sonal Sinha, appeared in this matter, and 6 for accommodation for specific instruction. Let the matter be urgent today and appear in the list. Let it matter appear in the list under the heading of to be mentioned on 20th.
20.
At first at 10:30. At 10:30.
Grateful, my lord. Grateful.
He's a nice chap. I cannot quarrel with him, my lord.
No, this type of money matters.
Revenue matters.
Revenue involving, my lord.
Actually, there was one deputy director. Now it has been bifurcated. Domdom area and Barakpur area. Difficulty arose, so far my North Calcutta goods are concerned, that is no role to play so far the Domdom deputy commissioner. But today I am under his control. Entire allotment has been made under the head of directorate. So Domdom cannot touch me, but the goods are in respect of the Domdom area. That creating the entire difficulties.
So who shall give the instruction?
That's a director, my lord. I'll come and then.
Actually, director is the
appropriate authority.
In one hearing, as I told, it is not pleaded. The director is also with me, but it is not pleaded in the requisition.
Very
grateful,
My
my
lord.
lord.
Call the list. New motion. No. Not today.
Lordship, I am for the petitioner, Lordship. I am playing for not today, Lordship.
Not today.
Yes, Lordship.
Why? You are not ready in this matter.
No, Lordship.
Okay, not today.
Great.
16. Not today. 17. আজকে গ্রুপ 6 এর পরে এটা নেব ঠিক ছিল তো? হুম? হুম? Give me papers.
My lord, item number 16, my lord.
I have already called it.
Item number 17, Lordship. I am attending. It is last.
16, my lord.
Okay, call 16.
Grateful, my lord. I'm for the petitioner, my lord. My lord, on the last occasion, my lord.
Take your breath first. Yes, item number 16.
16, my lord, on the last occasion, we also directed the state to file a report, my lord. On chief,
We have received an instruction lately, your lordship, we can provide a affidavit, a report in the form of affidavit in a week's time, Your Lordship.
What is
But
your
as per
prayer
the
here?
Instruction,
My lord,
Your Lordship, none of the
petitioner has applied
applicants
for
are eligible, Your
fair
Lordship.
price shop, and after time, now its status is showing it's rejected, my lord. But he has fulfilled all the criteria. He has his own go down as per the notification criteria, my lord.
Your Lordship, as per the instruction, all the go downs which are being shown as the eligibility criteria, all are incomplete under construction. And as per the instruction, none of the applicants herein are eligible, Your Lordship. All have been rejected on this ground.
But
Your Lordship, if Your Lordship pleases, I shall produce a report in the form of affidavit.
My lord, I can provide all the documents in support of
Yes,
statement.
then you file the report in the form
Yes,
of
sir.
affidavit.
Yes,
When it would be required? 1 week?
1 week's time.
Okay.
Grateful, my lord.
Learned counsel appearing on behalf of the state authority submits that the report has received containing inter alia that none of the applicants are eligible in connection with the state impugned vacancy notification.
And my lord, I'll file the exceptions if anything is answered.
Vacancy notification. The state authority intends to use affidavit. Concerning the submission, the authority is directed to file the report in the form of affidavit within a week. Full stop. Exception, if any, by the petitioner within next week. Let the matter appear in the list under the same heading on 5th of February. Next.
Grateful, my lord.
17 losses, I am appearing behalf of the petition.
17, my lord, I appear for the respondent number 2 and 3. On the
Yes.
last occasion, my lord, is directed to file a report. My lord, I am seeking a week's time only.
What is the matter?
Matter regarding petrol
Already-
pump for granting the license of
Okay.
petrol
The
pump.
license has been
1
granted.
week accommodation.
Just 1 week accommodation, my lord. It's ready, only the AOR is not well, and that's why it has not been informed. I am seeking for a week time.
Learned counsel appearing on behalf of the respondent number
2 and 3, my lord.
2 and 3. 6. Accommodation for extension of time to file. 6. Accommodation for extension of time to file a report in the form of affidavit. Let the report be filed within a week. No, within date kar do. Within 28th of January 2025. Reply, if any, against the said affidavit be filed within 7th of February. Let the matter appear in the list under the same heading on 10th of February.
Loss.
10th of February, my lord.
10th of
My lord. Grateful, my lord.
No. Loss instead of 10th, loss it was in another day 10th.
10 is the Monday.
Monday.
11 is the
I am not
11, maybe 11.
11 loss.
Okay. 11. You informed him. 11.
Hey, the loss is present.
Next.
My lord, I beg to appear for the state, my lord. My lord, if your lordship kindly comes to page 37 of the writ petition, my
Who
lord.
is for the petitioner?
My lord, no one is appearing, my lord.
You supposed to file affidavit.
My lord, but my lord, there is a, my lord, I'll file the affidavit, my lord, but there is your lordship, there was an earlier order by your lordship that the matter is, several appeal is pending before the division bench, my lord. So lordship may kindly give us time to file the affidavit in opposition, my lord. And in the meantime, my lord, the matter should be go out of the list, my lord. Liberty to mention, my lord.
Okay.
Because the petitioner herein has challenged the 2 notification, my lord, as the earlier writ petition, my lord. Page 37 is your lordship's order.
This is pertains to the pendency of 1543 of
My lord,
2024.
Even my lord, the petitioner has annexed the order of the of your lordship, and it is clearly reflected from that order, my lord, page 37 of the writ petition, my lord. May I read for your lordship, my lord?
Not necessary.
My lord. My lord, being MAT number 1543 of 2004, my lord.
24. It would
My
be
lord,
24.
it will be 24, my lord. Yes, my lord.
Okay, please take down. Learned counsel appearing on behalf of the state authority submits that the issue involved in the instant writ petition was raised before the honorable division bench was pending to be determined by that honorable division bench of this court in MAT 1543 of 2024. Being MAT 1543 of 2024. He submits that till disposal of the matter by the honorable division bench, this matter may be go out of the list pending the liberty of the না কি বললাম না তারা কি বলেছে পরিষদের পরে তার আগে full stop. Having heard the learned counsel for the party and considering the matter that the division bench is yet to dispose of the appeal being MAT 1543 of 2024. Let the matter go out of the list. With a leave to the state authority to file the affidavit in opposition. File a report in the form of affidavit file a report in the form of affidavit on the latter stage.
Deeply obliged, my lord.
Next.
I appear on
the
behalf of the
appellant's
state.
lordship, kindly praying for not this week.
Why?
Because AOR is on leave. Not this week only.
Not this week. Next. Then none appears on behalf of the petitioner. Let the matter go out of the list.
One.
21 has done. Next. 22, 23. Then. Similar order. None appears on behalf of the petitioner. Let the matter go out of the list.
Report. 24 Milord, I am for the petitioner. Now this is the affidavit of service, Milord. Lord, this is second time of it petition, Milord. Second round of the petition. Lord, Lord, kindly have a look, Milord, page 71 of my petition, Milord. Page 71. There is your lordship's order.
Page
71. Your lordships dispose of the matter by considering my representation. But, my lord,
yes,
hearing took place and page.
May I be excused, my lord? 22, 23, instead of, my lord, out of list, your lordship. I am running from, my lord. Kindly make it not today.
My lord, I am for the state.
22, 23.
Yes, ma'am.
What is the matter?
My lord, they have challenged.
My lord, pursuant to your lordship's leave.
My lord,
You just wait.
kindly, my lord, the prayer is, my lord, they have made a prayer for, my lord, refund of, my lord. They claim, my lord, there was a shortage. We have, my lord, taken a stand that there was shortage. And, my lord, accordingly, penalty was imposed. My lord, they claim, my lord, that there was no shortage because, my lord, during the COVID, my lord, it was given for emergency purposes to the, my lord, Panchayat Samiti. My lord, our stand is, my lord, there was no such order. But we have instructed.
He has shown some order.
But there is some correspondence from their end to the authorities that they will give. But from the authorities, there is no. We can submit the report, including all those documents.
My lord, page 37, it is their own order. My learned friend says, my lord. My lord, this letter has been issued to the Subdivisional Controller, Food and Supply, Arambagh, to the District Controller. This is an admitted position that I have given as per their request. And my lord, what has happened, my lord? I am to license. I am a distributor of MR. This is, my lord, I have given and supplementary also prepared pursuant to lordship's leave.
Use affidavit.
Lord, we will file a report in the form of affidavit, my lord, citing, my lord, the fact situation.
Yes, yes, I have no objection. My lord, kindly supplementary affidavit pursuant to lordship's leave be taken on record in both the matters, my lord.
But in 22, my lord, I am appearing. 23, I am not.
23, 24.
22, well, this is analogous matter, same. 23. Yes, let them file affidavit in opposition or, my lord, report in the form of an opposition, and kindly be allowed me to file an exception. I have served, my lord, I have served. I have done on the basis of the, my lord, the request of the food and supply authorities. Now, subsequently, for deficit stock, I have been penalized 17 lakhs.
Okay. Please take down.
Lordship, I am appealing to the state respondent.
Yes, 22 days.
23. Lordship,
Out of list করেছিলাম না?
Reporting.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Respondent, no, learned counsel appearing on behalf of the respondent, state respondent intends to file a reply. Intends to file a report in the form of affidavit. Let the report be filed within 2 weeks.
Lordship,
3 weeks, my lord,
3 weeks.
because of the.
Within 3 weeks from date. Reply, if any, by the petitioner within 1 week thereafter. Let the matter appear in the list on 17th of February.
My lord, in the meantime, my lord, since there is no scope for any, at least, my lord, no coercive steps should be taken because, my lord, regularly I have been harassing. They have made an inspection. Since, my lord, I have filed writ petition. My lord, recently, yes, recently. My lord, I am submitting with full responsibility. My lord, recently they have, my lord, given an inspection and, my lord, issue several letters.
My lord, no scope for any interim order is there. My lord, the question is of what penalty they have, my lord, even TR forms, my lord, they have shown.
Yes, I have given 7-8 lakhs.
Okay.
My lord, at least no coercive measure should be taken in the meantime.
Whether any coercive action has been
Yes,
taken?
my lord, they prior to, after filing this writ petition, they have issued letter, they have made an inspection. Again, my lord saying that I have deficit stock, so I have been penalized,
I will-
going to impose penalized.
I'll deal with this matter later.
Yes,
Let them file the report.
blanket ban.
I will file that.
My
I will deal with the matter. No issue.
But after filing this writ petition,
Very well.
My lord, and my lord,
17th of February. Within 3 weeks,
my lord,
affidavit, reply within 1 week. 17th of February, hearing.
grateful to you.
one, my lord, request, my lord, my learned friend, my lord, can my lord, he serve a fresh copy, my lord? None of the page numbers are there in the copy that I have.
You serve a face.
কোনটা কোনটা
রিট পিটিশনের কপিতে কোনো পেজ নাম্বার নেই আপনি যেটা
ওটাও পেজ নাম্বার করে দিচ্ছে কি আর?
সেটা আপনি করে দিন
Yes,
So it
do it.
could match
Yes,
with
yes.
the
That has been done. But I send my clerk to make it paginate. I do not know.
Okay, next matter.
Yes, my lord. Lord, I am for the petitioner, my lord.
Yes.
Lord, page 71, my lord, your lordship's order, my lord. Lord, may I read the order, my lord?
Yes, read out the order.
The husband of the petitioner, namely Lutfar Rahman Molla, was granted MR dealership by the concerned state authority. It is the case of the petitioner that after demise of her husband, she preferred an application for appointment of herself as a MR dealer on compassionate ground. The said application was not considered by the authority concerned. Accordingly, the petitioner approached this court in a WPA number such and such 2016, wherein this court has given liberty to the petitioner to file a separate writ petition afresh on the basis of self-same cause of action. The present petitioner has submitted his demand of justice through his learned advocate by the correspondence dated 16th August 2024 by annexure 11. It is the case of the petitioner that the concerned authority has not taken any decision in respect of the said representation. Petitioner seeks necessary direction upon the concerned authority so that the concerned authority to make a reasoned decision after giving reasonable opportunity of hearing to the petitioner. Learned counsel appearing on behalf of the state submits that she possessed entire instructions from the authority concerned, but if the petitioner intends to proceed with the representation, necessary direction may be passed by this court. Having heard the learned counsel for the parties, it appears to me that the concerned authority has not taken any decision till today on the basis of representation of the present petitioner through his learned advocate dated 16th August 2024. Under the above observation, the authority concerned is directed to take appropriate decision on the basis of representation dated 16th August 2024 of the petitioner being answered P11 to the writ petitioner and passed a reasoned order after giving reasonable opportunity of hearing of being heard to the petitioner. The authority concerned is directed to take the appropriate decision within a period of 6 weeks from the date of communication of this order. The authority concerned must have heard the petitioner before passing the reasoned order. The authority is further directed to inform the reasoned order to the petitioner within 2 weeks after passing the reasoned order. My lord, this is the order, my lord. Thereafter, my lord, what happens? Page 13, page 74, annexure P13. Reasoned order taken by the authority concerned, mother.
Yes.
As per kind instruction of the competent authority of the department by e-file number such and such, dated 19/9/2024, is connection with WBA number 21357 of 2024, such and such, the West Bengal respondents, a personal hearing of Murshida Begum was held on 28/10/2024 at 3 p.m. at the office chamber of the undersigned and reasoned order and recorded deposition. After scrutinizing all relevant documents and the deposition of personal hearing, now the undersigned also informed her at the time of personal hearing on 28/10/2024 that her application does not arise as compassionate case because the FPS concern was not tagged due to the death of the dealer. As a result, the prayer of Murshida Begum for engagement as FPS dealer on compassionate ground has already been rejected by the competent authority of the department by memo number such and such this, my lord. And the same was intimated of Murshida Begum, wife of such and such, by the office undersigned by memo number such and such at this. My lord, this order was challenged, and this, my lord, was not tagged due to the death of the dealer. But my lord, kindly have in this regard, my lord, what I made a representation before the authority concerned, that my lord, that is at page, my lord, 75, annexure P14. That I have been instructed by my aforementioned client that on the basis of the order of Honorable High Court Calcutta, you took a hearing on 28/10/2024 with regard to appointment of MR dealer in favor of my client, but after scrutinizing all relevant documents and deposition of personal hearing for compassionate appointment of my client,
was turned down on the ground that APS concern was not tagged due to the death of the dealer. But in black and white, the husband of my client made an intimation to you on 8/9/2008 with regard to hand over the said license to him as he was recovered from ailment, but after providing fit certificate, you did not provide him the said license, which is unknown to him. That is the crux of the matter, my lord. And whether, my lord, whether he was involved in criminal activity, whether he was involved in defalcation of money, whether any intimation was given to him that he was involved in such activity, then under which provision of law you did not take any step with regard to the letter dated 8/9/2008 and 21/10/2008 respectively. Therefore, my client cannot suffer for your willful and deliberate negligence. My lord, because I made an intimation, my lord, in the year 2008. Kindly see, my lord, page 77-6, that আমার বিনীতি নিবেদন এই যে আমি বালুচুরি গ্রাম পঞ্চায়েতের কলিয়া গ্রামের একজন
That is not the issue. That is not the issue. Issue is that they have passed an order.
Yes, my lord.
Already they have passed an order which was intimated to you in the year 2016. 2016 they have passed the order.
No,
They have disposed of the matter. Why
No.
you not challenge that order?
That order was challenged, my lord. That order was challenged. That is why
You know the reason why it was cancelled.
no, that order was challenged, and my lord,
It is not a fact of compassionate appointment. It is otherwise than the compassionate appointment. Your husband license was terminated. Order of termination was there. They have given the date in the region order.
No, my lord.
Ask for the copy by RTI.
No, my lord, kindly one thing is this, my lord, that my husband expired. My husband expired, but before expired, before expired,
His license was terminated.
no, before, how it was possible, my lord? That is why,
You take the order. You take the order. They have given the order. They have given the date of the order.
that
You
is why
take the order from the department.
that is why I made a representation, my lord.
No. Representation will not suffice. You take the order. They have given the date and number of the order itself. You take a copy of the order from the department. RTI is there. Why you before this court?
No, my lord, first of all, one thing is the kindly appreciate one thing, is lordship, that APS concern was not tagged due to the date of the dealer. The whether not tagged with the due to the death of the dealer, that was my fault or the fault of the department, Lord, because I informed the department right in point of time.
No. You are not taking my point. The dealership license of your husband was terminated. Was terminated by the concerned authority prior to his death. There is order. He has mentioned
No,
the
my
order
lord,
in the written
but my lord, when I was recovered from my ailment, thereafter, my lord,
Your recovery is not the case. Departmental action was there against him.
no, that is why, my lord, I made a question about that whether
They have made the specific order, number of order, date of order. You take those orders. The region order is specific. What is the order? What is the date of the order? What is the memo of the order? Everything is there. You take those orders and come to this court.
so, my lord, they will not provide any information, my lord, from the department,
Anyone
because
come here.
my lord, if you lordship,
RTI, you file after RTI application.
your lordships kindly consider this representation. Otherwise, they will not provide that.
No. This is not a RTI court. You file RTI application. They have provided you the entire number, date of the orders. I never seen such an order, region order like that. They have mentioned each and every orders.
But reason order by one line they have made order. Can you read this? Can you see this order? Reason order?
Yes, last
74.
last 4 lines you read.
The same was intimated to Murshidabad. Yes, that was intimated to me. That is at page 60. Is my repetition is there. I have challenged that order. That is at my lord page, my lord, as 57. 57. Kindly see this. With reference to memo number Sergeant sir, this is to inform you that the compassion does not arise in the instant case because APS concern was not tagged due to the death of the dealer. So the prayer of Simita Murshida Begum for engagement of as APS dealer on compassion ground has been rejected by the director.
You file the application, specific application with the authority. Got the order. If you not, receive the order, then you come to this court. File afresh. Okay. File afresh.
So kindly give me one protection, my lord.
I am disposing the writ petition
Yes.
with the liberty to file afresh.
Right.
Okay. Having heard the learned counsel for the petitioner, the instant writ petition is disposed of with the liberty to sue afresh on the self-same cause of action. Affidavit of service filed on behalf of the petitioner. Sue afresh. Sue afresh on the basis of self-same cause of action. Next para, affidavit of service filed on behalf of the petitioner.
Well, a copy of the order be supplied to the department concerned, my lord.
Which copy?
This order, copy of the order.
What is the purpose of copy of the order?
Because
take the
my lord,
order?
if they take a decision,
They have
against-
taken the decision. You have to
No,
find out the order.
Yes, my lord. If my
finally-
lord, department taken the decision that my retribution will be infractious, my lord, against this vacancy or something like that.
And I cannot understand what is your
My
saying.
lord, if my lord,
Your writ petition is now disposed of with a liberty
to file
to
afresh.
you file afresh.
But
Okay.
my
So
lord,
what you want now?
my lord, one thing is, my lord, if this order be communicated to the department concerned, my lord, on the other hand, if department take a decision against this vacancy, that is the question, my lord. If my lord already
No,
fulfilled the vacancy.
future aspect cannot be considered now. Next,
Yes, Ahmed.
this is the future.
Yes, my lord.
I beg your liberty to appear on behalf of the petitioner, my lord, in item number 25, my lord. My lord, I am on behalf of petitioner in 25 number, my lord.
Yes, what is the matter?
My lord, the petitioner is a senior citizen running FPS since 1985 without any single allegation against him. He is serving the, this is regarding the notification on the service area on which the petitioner is running his FPS shop. The license, I am praying for the usual order, my lord. The license is at page number 16. Service area is Balijol and Kautal.
Balijol.
Yes, my lord. Balijol and Kautal. And 18 is the notification, my lord. Along with Balijol,
Balijol,
Kautal.
Kautal.
Yes, there are 3 addition.
My lord, if I may submit something, my lord, in this writ petition, the petitioner has not challenged the existence of 2013 control order. No pleadings, no ground.
Nothing is there.
Nothing is there, my lord. They have not challenged the existence of petition of 2015 control order, my lord. No pleading, no ground, no prayer, nothing at all.
Sure, press.
My lord, I have taken the ground that one nation, one ration card, if it is implemented, so anybody can take item from anywhere. So I have annexed that order also, my lord, in page number.
There is no pleading.
In that case, my lord, same order cannot be passed, my lord.
Yes, there is no pleading.
No, it was pleaded, my lord. No, one nation, one ration card. This is the last page, my lord.
You have not challenged the WPDS control order 2013.
Yes, my lord, that is right.
Where you challenge?
No, I have not challenged, my lord. After promulgation of National Food Security Act 2013, the targeted public distribution control order 15 is redundant. But I have not taken that ground, my lord, that time. But I have taken the ground that if it is implemented, if the new dealer is appointed in my service area, there is every possibilities that the person whom I am serving, they can switch over to the new dealer and equally
Have you understand? Have you understand the contention of this court? If
Yes,
you,
my lord, I understand, my lord.
if you try, if you want this order, you have to file a fresh writ petition. This is there is no such pleading.
Yes, my lord.
Okay.
There is no such pleading.
On the prayer of the learned counsel for the petitioner,
My
let
lord,
the
kindly give me
instant writ
liberty to
petition be
file afresh, my lord.
disposed of with a liberty to the petitioner to sue afresh on the self-same cause of action.
Obliged, my lord. Obliged, my lord.
My lord, Mr. Ganguly's name may be recorded, my lord. I am
the-
led by Mr. Ganguly, my lord.
Okay, you give me the names.
Yes, my lord.
And I'm going to
Great, my lord.
Obliged, my lord.
next.
26, my lord, I am appealing for stay.
Who is for the petitioner? No one is appearing.
No one is appearing.
What is the matter?
Challenging the selection process of the
Election.
APS, my lord.
That is represented through learned counsel Mr. Amrudallah Chatterjee. None appears on behalf of the petitioner. That is represented through learned counsel Mr. Amrudallah Chatterjee. To the learned counsel Mr. Amrudallah Chatterjee. Mr. Amrudallah Chatterjee. None appears on behalf of the petitioner. Let the matter go to the list.
Grateful, my lord.
27, my application, my lord. Your lordship will be used, my lord. Here the typed copy of the notification which was not received. That's why I have submitted. And yes, my lord. The notification, my lord, which I have typed. My lord, the vacancy notification issued by the authority, my lord, that will appear, my lord, the page, my lord, 17. A typed copy has been given. Page number 3, serial number 4. My lord, that is 194.
Page
Ramnagar 2.
Page 3. Page
My lord, at the top.
Page 3 of the type copy.
2 columns, my lord, top, page 3. Ramnagar 2. Memo number 194 CFS 2024 dated 16 May 2024.
Ramnagar 2.
Ramnagar
Serial
2.
number?
Serial number 4.
Phone number 194.
194. That is there, my lord, and similar order has been passed by your lordship, my lord. That will appear, my lord.
What is your license?
And the license is, my lord, at page, my lord, 14 and adjacent area of the same. Mouja Uttar Sitola and other adjacent villages, including the same. And other adjacent. A second round, my lord, your lordship on the earlier occasion granted leave to file afresh. That's why I have filed the petition, my lord. Pursuant to leave granted by your lordship. The earlier writ petition was, my lord, WPA 22803 of 2024.
Page paragraph 9.
Paragraph 9.
Page
Your lordship directed me to file. A subsequent deed has been filed, my lord, including the memo number separately.
Okay.
Because that notification was earlier, my lord, district-wise, so that it has been individually filed before your lordship. And that's why I'm praying, my lord. 194 dated 16 May 2023. And on the earlier occasion, the typed copy was required to be seen, my lord, by my learned friend, so that I have handed over such typed copy to him, because it was not distinct before your lords. I am very sorry for that, my lord. That's why I am praying before your lords.
Okay, okay.
It's 194 dated 16 May.
Serial number
Only this.
Serial
nothing
number
else.
4.
Serial number 4. Within the vicinity of my lord Ramnagar 2 block. And the identical order had been passed by your lordship.
Very well. Pendency of 1543 of 2024.
My lord, yes,
What is the status of that appeal?
my lord, the appeal, my lord, is there 1543
Of 2024.
24, my lord, and other appeals, my lord, tagged together. My lord, the order which was passed was that
Not to delink or not to.
yes, and that
What is the
order
order?
is continuing to my
That is
lord.
continuing.
It is last order.
Your lordship
What is
has
the
deflected in-
date of the final hearing?
This order was of Lord, I'll apprise you, Lord. This was 6th of August 24. Yes. Lord, the last order I have I have seen that order. Man. Kindly bear with me for a moment. এটাই দেখছি last orderটা আছে আছে।
এটা reflected হয়েছে জজ সাহেবের order. My lord has also noted that division bench appeal.
Yes.
You order yourself.
It is my lord continuing. That is
Continue.
there. That is
Okay.
that much I know.
Please take down. Affidavit of service filed on behalf of the petitioner is taken on record.
Sure. Party.
27 and 8.
27, 28.
এটা এই কি অর্ডারটা আছে আগে থেকে সেম হল জানিয়ে নি Similar order, considering the situations and considering the efforts of submissions, state authority is at liberty to proceed with the selection process. But so far as the grant of license is concerned, the same shall not be issued till the disposal of the batch of appeals pending before the learned division bench, being MAT 1543 of 2024. নাম্বারটা ভুল আছে 2004 আছে দেখেন পুরোটা কিছু নেই আমি চেক অর্ডার করছি next
And 28 next one, same my lord of the same my lord block, my lord only 153 serial number 2. Your lordship will be only to us.
Type.
Serial number 2.
what serial
153 dated 13th May 22.
আমাদের কাছে কোথায় লিস্ট আছে লিস্ট তো
জয় সাহেব কো check.
লিস্ট একটু দেখান তাই
Page 3. Ramnagar block 2.
Yeah.
Serial number 2. Memo number 153 CFS 24. Puja Kanpur.
and you prepare one copy for two
My
cases.
lord.
one copy should be handed over
I will hand it.
no it should be handed over right now so that I can verify otherwise any একটা একটু দেখতে ভেরিফাই করতেন কোনটা
Thank you. 2 number serial one.
Serial number 2.
এখানেও আছে 153.
ভেরিফাই
153.
153
Yes, my lord, 153. Serial number 2.
Oh, sorry.
বলছি যে
Sorry.
something
Again,
Sorry, my lord, serial number 160.
160.
I am very sorry, my
160.
serial number 1.
606.
Serial number 1, your lordship. Page number 3. Ramnagar 2, subdivision contact.
where is the memo number 160 CFS?
Yes,
160.
under serial number 1, madam.
Serial number 1.
160.
160.
Same order.
Similar direction. Similar direction.
হ্যাঁ এবার থেকে এটাতে না ক্লিয়ার কাট
আমি জানি, বুঝতে পেরেছি।
অসুবিধা হয়
ঠিক আছে।
আচ্ছা
এটা দিয়ে দিচ্ছ।
29, Your Lordship, I appear on behalf of the state, Your Lordship.
I'm for the petitioner. On last occasion, I have started my argument by could not conclude according to Mr. But this is a selection process.
Yes.
But selection process is under challenge. So for the selection of my learned friend's client, the private respondent, on page 32 is the vacancy notice.
Whether it can be disposed of without affidavits?
Can be, because there is a direction of the court upon the district magistrate to consider my representation. After expiry of the time, a notice has been given to me. Please come and attend the hearing on so and so. Just before that day, I got admitted in the hospital and intimated a letter that I am in a government hospital, I cannot go there. Despite receiving such letter, in presence of my learned friend client, hearing has been concluded. And after 4 months, final order has been passed. Prior to that, I again gave a letter that in my absence could not do it. Please arrange a further hearing. So, according to my understanding, your lordship may remit back the matter to the secretary or the director, not to the district magistrate. Because possibly this is the principle of natural justice. Even your lordship knows, when a matter is remitted back by the division bench to a learned single judge, even if none appears on behalf of the one of the parties, at least 1 day time should be given.
What order has been passed?
Upholding the selection of my learned friend client.
You challenge the order before this court? This court directed the
District magistrate to consider after providing opportunity of hearing.
But you have not given the opportunity.
On the
That was
day,
prevented by
notice has been given to me. I got admitted in the government hospital. I wrote a letter intimating them. And so far the merit of the case is concerned, my specific case is that my learned friend client is not at all eligible candidate, having no shop come go down in the advertised location.
Your Lordship, the reports have been annexed. The order impugned herein, Your Lordship will kindly see page 81, 82. The entire data which was collected upon inquiry, upon field inquiry by the officer concerned have been indicated in the order, which clearly shows that the area measurement of go down, whereas the.
However, he was not heard. He was admitted
Your
in the
Lordship,
hospital.
to that extent, Your Lordship, I need to take instruction. In that event, if Your Lordship pleases to send it back, we shall consider it afresh and pass a reasoned order. Your Lordship, the reports have been annexed by the petitioner himself, where it clearly indicates. Your Lordship will kindly see
May I just read one paragraph?
Your Lordship, kindly
come to page 83, the order impugned, the odd party portion, page 83. Order. Your Lordship is at page 83.
Yes.
Ordered that the claims as contended by the petitioner in the instant hearing. Total non-application of mind. Admitted position, I was not there. And when the order has been passed, and when the hearing has been taken place, kindly see. Possibly Mr. Bandhavadi is not ready to test, right? পড়ে আছে ও বিটটা পড়ে আসেনি বলছি আমি বলবো Hearing notice page, kindly see, my lord, 7th September 2024 at page, my lord, 72. 13th March 2024. Then my letter annexing all the documents so far the hospital is concerned. Then next letter, page 77, 4th April. Then order has been passed in May. Hearing March, May. During this period, he should have been given an opportunity of hearing. This is much after the stipulated time given by the Honorable Court. On last occasion, my learned friend raised some primary objection regarding the acknowledgement of the document which I have annexed. Legible copy ছিল না annexed হবে আপনি আসুন So let this matter be forwarded to the, because there are 3 inquiries. So far I am concerned, 1 inquiry, subsequent to that, fresh inquiry in respect of the private respondent only. That's after 4 months. My specific case is that on the date of first inquiry, there was no shop-come go down. It was being constructed. I have given the photographs also. Let the matter be sent to the secretary. Let him take a decision after providing opportunity of hearing to all the parties.
No,
Inquiry report says otherwise, Your Lordship.
at the case of remand, the authority who have heard the matter will be sent to.
He has not heard me. Now the
Page number
before,
82.
at the time of moving first writ petition, I had no problem so far the DM is concerned. Now the conduct of the DM shows who is the chairman of the district level selection committee. He don't want that I should be given the license.
DM is not the
Chairman, he's the chairman. But he's sending the deputy additional district magistrate.
Perhaps the chairman.
Additional district magistrate is being done by the additional district magistrate, but he is the chairman according to the provisions of law. ADM is the chairman. ADM he is sending to the ADM in all cases.
Yes.
As the member of the committee, rather the chairman, but DM is the chairman.
Yes,
Your
Mr.
Lordship,
Bandyopadhyay, what
notice
can be
was
done here?
given. Your
Let
Lordship,
it be sent there.
Your Lordship, the notice was given, hearing was conducted. Your Lordship will kindly see page 82. And the entire order has been passed based on the inquiry reports.
I understand.
There were 3
Order was
inquiry
passed on the
inquiry.
basis of the inquiry report, but he
Your
was
Lordship,
not there.
notice was given. He chose not to appear, Your Lordship. The fact remains that notice was given. It has been recorded in the order that
No,
notice
he
was
was
given.
admitted in the hospital. There are evidences.
Your Lordship, that has. Your Lordship, may I?
Yes, Mr. Bandyopadhyay, what can I do?
This, on the first occasions also, my lord, the petitioners made out a case that he was the better candidate. In fact, my lord, on his complaint, my lord, the second inquiry took place. Then after, my lord, it was referred to the before the district magistrate by this honorable court, my lord,
Yes.
directing specifically that you make an inspection. Kindly see the last or the earlier order of this. The district magistrate made an inspection and found that there was no basis in his complaint. That is the specific findings. Now, a better candidate has been given the appointment. I was running more than 1 year. I was running. Now, again, this writ petition is made. I have no specific instruction that whether he appeared or not, and the particular notice, whether it was his letter, whether it was actually submitted. And the annexures which he annexed, didn't bear the stamp. Now, I am given a copy which shows it a stamp. But kindly take the next representation, page, only one document.
No, the date was fixed on 13th of March.
13th of March.
He wrote
Now
a letter on 11th of March.
Yes, now this was probably received by the officer of the district magistrate. It was tried. This case was made out, page, I don't know what is this page number, 73. This is the stamp, they said.
No, I haven't given the state is not saying anything.
There is no question of my making substance, my lord. Page 73.
Is that it was not stamped at page 73, and now it is therefore.
Now they are, my lord, producing a letter which bears the stamp. Now kindly take the next letter, which actually given.
I handed over the copy, and this is the better copy, and I can bring the original also. If my learned friend, and my learned friend maybe take instruction representing the state that whether this letter has been handed over or not. This is all allegation I am not accepting. With all medical documents.
But kindly take page 77 then.
No, whatever, maybe there are government documents, hospital documents, admission 11.3, discharge 13.3.
Now, kindly see the who has issued this. This is primary health center. There's no admission. My lord, I don't think she was admitted. There's a document of
Discharge was there.
page 76.
Discharge certificates are not issued by any authority, by any government.
My lord, this order says that there was, but it doesn't record that the petitioner was not absent. My lord, she may have been represented by someone, by any lawyer or by his representative.
Recording?
But there is no such recording. My lord, on the contrary, kindly take, my lord, the decision.
The presence of the petitioner is not there.
That on
You can
13th,
challenge
now kindly take, my lord, 79, 13th March 2024, the matter was heard. How it was heard? My lord, first paragraph. Somebody represented the petitioner.
That cut both way.
Somebody must have represented the petitioner. Now they are, when this order goes against them, my lord, they come out and make out a different case.
Very well. Okay.
What expected from Mr. Bondar?
My lord, I need, my lord, in that event, my lord, I need to file an affidavit or I need to take instruction.
Let the state take instruction. Let the
state
state
produce the records.
Yes.
Let the state produce the records. My lord, showing that it was, if it was not, no, they,
How can you challenge the discharge certificate?
I am not challenging, but somebody could have represented him.
Where is the recording?
अरे बाबा चिৎকার করলে তো মামলা করা যাবে না
No. How can you?
Malad, I was not there before the authority. Now the authority records that on 13th of March 2024 the matter was heard.
And he is saying before this.
Now he is saying
he was not there.
Sure. Now the records can say that suppose Pingal
I was in hospital.
Some advocate, local advocates could have represented.
There must be some written.
That
why not there?
That is available with the state.
No, order is not there.
Orders records that in compliance this notice was given and hearing was taken on 13th.
No, sir. Kindly come to page 82.
Kindly come to page 79, first paragraph.
Page 83, that the claims as contended by the petitioner in the instant hearing. I was on the hospital, page 83.
That is the ordering portion.
Yes.
Now kindly take the first page, 79, first paragraph. 79, first paragraph.
What is the problem? Let my learned friend take the instruction from the DM. He's the party. Come on Monday.
No. I am disposing of this.
And I'm praying for my lord, at least secretary or the director.
No, it cannot
the
be.
DM. Why? That's the whole difficulty. There are three inquiries.
My lord, if I am not allowed to make any submission, then what is the requirement? Mr. Shahara is appearing. There is no other party in the court, only him. My lord, this remand was made. This order was passed upon a district magistrate by a competent court of law.
Yes.
Your lordship is
generally remand is on the.
It should be before the district magistrate.
Before the authority who has heard.
Yes. Sometimes I feel that when Mr. Shahara is appearing for the petitioners,
May I submit one thing, my lord? So for the DM is concerned, his biasness has been proved. Despite my
an IAS officer,
despite my non-appearance, it has been recorded I appeared. Even if your lordship sent the matter to the DM, I am
say
no. You have the scope to challenge the order if any order is passed, but you appear before.
Your lordship think
I am not going to the merit of this.
Your lordship think person who has already rejected my prayer, saying that all the reports in his favor, where I have made out a case that subsequently inquiry has been conducted only in respect of the go down of the private restaurant, not me. That document says. Now the district magistrate is the chairman of the sub-selection level committee. He already considered the matter and selected. Ultimately, he has again rejected. What is the harm if the director, I am not saying the secretary, if the director is considered, what will be the harm?
No. In the matter of the remand, if I remand the matter, it has to be the authority who heard the.
As well.
Otherwise, it will
There
be
is no violation.
against the order.
All
Okay,
the
okay.
order has been passed
I am
on
not
this-
passing any
I
order.
your lordship.
I am not passing any order on that point. The instant writ petition was prepared by the petitioner on with innocuous prayer that by earlier writ petition being number WPA 21720 of 2023, a coordinate bench of this court has directed district magistrate and collector Murshidabad to hear out the parties and pass an region order. Full stop. It is the case of the petitioner that the parties and passed an region order. The region order was passed by the concerned authority on 16 by the district magistrate on 16th of May 2024. It is the case of the petitioner that he received the notice of hearing from the district magistrate, which was fixed on 13th of March 2024. Full stop. It is the further case of the petitioner that he was admitted to the hospital on 11th of March 2024 and discharged at the evening of 13th of March 2024. Consequently, he could not appear before the learned district magistrate on the date of hearing when the matter was called on for hearing. However, he made a representation with the district magistrate before passing of the order, but his representation was not considered and the district magistrate has passed the impugned order. It is the submission of the of Mr. Saharai, and the senior advocate who are appearing on behalf of the petitioner that the matter may be remanded back to any authority to decide the issue afresh in terms of the direction of this court, dated WPA number 21720 of 2023. 21720 of 2023. Mr. Sagar Bandyopadhyay, learned counsel, senior counsel, appearing on behalf of the private respondent, raised objection to the fact that the impugned order does not mention that the petitioner was absent. He submits that may have the representative of the petitioner may representative of the petitioner have present at the time of hearing. Learned counsel appearing on behalf of the state authority submits that the impugned order passed by the district magistrate is very specific and on the basis of the materials and documents and report issued by the SCF is concerned. Having heard the learned counsel for the petitioner, also considering the document regarding admission of the petitioner and discharge of the petitioner from the within bracket as it appears from discharge certificate issued by the Pritimoi Rural Hospital, Tehotto 2, Palasipada, Nodia. I get close. Tehotto 2, Palasipada, Nodia. I get close. Regarding admission and discharge, admission and discharge of the prisoner. Admission and discharge of the prisoner. Comma. It's a certificate dated for the dated 13/3/2024 by the Prithimoyi RH Rural Hospital. RH. They have to do scholarship and packet close. It appears that there are reasons to believe. There are reasons to believe. Reasons to believe that the petitioner was not present at the time of hearing before the magistrate when the hearing was called on, or the hearing was taken place on 13th of March 2012. Hearing was taken place on 13th of March 2024. Considering the circumstances, I think it fit to remand the matter to the district magistrate and collector district Murshidabad to rehear the matter in presence of the petitioner and other interested parties. Petitioner, private respondent, and other concerned officers.
Date may be fixed. Again, they will somehow they will come again.
No, I do not know whether the collector will be available in a particular date or not.
A district magistrate is the IS officer. He has
Yes,
some jobs.
collector will be available or not. So I can pass a honor.
Within double page district.
Accordingly, the instant petition is disposed of with a direction to the district magistrate concerned to rehear the matter and rehear the matter in terms of WPA number 21720 of 2023. In terms of order of this court, in terms of order of this court dated order of this court in WPA number, such and such. Full stop. The district magistrate shall dispose of the district magistrate shall hear out the matter in presence of the petitioner and shall communicate the order to the petitioner after taking the decision within 2 weeks thereafter. Full stop. The district magistrate shall complete the exercise within 8 weeks. Within 8 weeks from the date of communication of this order by the petitioner. Full stop.
An order will be quashed, man. Otherwise, this is going to dated 16th.
Consequently, the order
16th May 2024.
Order impugned dated 16th May 2024 is set aside. Full stop. Next paragraph. As affidavits are not exchanged, allegation made in the writ petition shall be deemed to have been not admitted. Full stop. I make it clear that this court has not entered into the merit of this matter. I made it clear that, comma, this court has not entered into the merit of this matter. District magistrate concerned shall dispose of the matter according to the law without being influenced by any order. Without being influenced by any order of this court.
Get much obliged, Lordship.
Without being influenced by any orders of this court.
Okay. I've got much of
it.